Titles in Commerce, featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to this Saturday, June 12th edition of Money, Banking, and Trust by Moving Titles in Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology, and we'll go to the disclaimer next. Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and our short recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Again, I'd like to welcome everybody to this Saturday edition. We're going to pick up again in Corpus Juris Secundum, Book 30A, and we're studying the section on equity. And last week we left off on page 201 under Section C, Particular Grounds of Jurisdiction. And this is out of the Book 30A, Corpus Juris Secundum, and that's the 1992 edition. So we're picking up on Particular Grounds of Jurisdiction. 1, General Considerations, Section 35 in general. As a general rule, a bill in equity cannot be maintained unless the suit falls within some recognized head of equity. Well, as a general rule, a bill of equity cannot be maintained unless the suit falls within some recognized head of equity jurisprudence. An accurate statement of the subjects of equitable jurisdiction is a matter of acknowledged difficulty, although there are certain well-recognized heads or classes which are considered in detail infra section 36 through 71. And the fact that the principal case is not one of a usual class or cannot be classified under such a head will not in itself preclude equity from taking cognizance of it. There must, however, be involved facts giving rise to an equitable right as to which there is a power to grant some equitable relief. The fact that the particular litigation raises a serious question of law is not in itself sufficient to support equity jurisdiction, where the duty to be performed is conditional and for an infinite period. The remedy may be an equitable one requiring a bond or a creation of a trust fund. While it's been stated that equity is reluctant to assume jurisdiction of a case and that it has no intention or even desire to enlarge the boundaries of its jurisdiction, it has been stated, on the other hand, that courts be tenacious in preserving their equity powers and jurisdiction, notwithstanding the uniting of equity and legal jurisdictions in the same court. Courts of equity go much further, both to give and to withhold relief in furtherance of public interest that they are accustomed to go when only private interests are involved. The assertion of a set-off or counterclaim which is of an equitable nature or not enforceable in the law courts may support equity jurisdiction. Next section, avoidance of irreparable injury. The avoidance of irreparable injury is a ground of equity jurisdiction. Indeed, the avoidance of irreparable injury is an indispensable basis for the exercise of equity powers. The jurisdiction of equity rests on the fact that unless it acts, wrong will be perpetrated which cannot be remedied, and substantial injury must exist or be reasonably apprehended to warrant the exercise of equity jurisdiction. Next section, enforcement of moral duties. Enforcement of moral duties unconnected with legal obligations is not within equity jurisdiction. Next section, hardship of particular case. A court of equity may not assume power to administer justice because of the hardship of a case. Equity will act to prevent imposition on one person of a burden which ought to be borne in common. Next section, infliction of punishment. Equity jurisdiction does not extend to the infliction of punishment except in instances which punishment is used to sustain or enforce its jurisdiction. And now enforcement of statutes. Equity will enforce statutes for the benefit of those entitled to relief. Courts of equity have inherent jurisdiction to give effect to the policy of the legislature. The systematic, repeated, and continuing violations of the Constitution or the law to the injury of a complainant present ample ground for relief in equity. Next, invalidity of statute or ordinance. The invalidity or unconstitutionality of a statute or ordinance is not of itself a ground of equity jurisdiction. The power of equity to determine the validity of laws and ordinances is only incidental to the protection of rights recognized in equity. Next section, relief against positive rules of law or statutes. Equity has no jurisdiction to repeal or to relieve against a statute, nor to relieve against an operation and effect of positive rules of law. It does not rise above the common law and the statutes. However, equity has a right to prevent the enforcement of a legal right whenever such enforcement would be inequitable. Next, relief in contravention of law or public policy. When the law, out of consideration of public policy, denies a remedy, equity cannot grant one. The effect of remedy which will support a resort to equity must lie in the legal remedy and not in the legal policy. Equity may not enforce which is forbidden by law, and it will not lend its aid to accomplish by indirection what the law or its clearly defined policies forbid to be done directly. Next section, 36. Equitable relief as grounds of jurisdiction. A, general. Equity may assume jurisdiction in order to provide relief which is not obtainable at law. In many cases, the jurisdiction in equity depends chiefly or altogether on the inadequacy of the relief obtainable at law and the consequent necessity of invoking the more direct and specific remedies afforded by equity for the protection of rights in themselves sufficiently recognized at law. When the remedy is one which only equity can administer, equity has exclusive jurisdiction. On the other hand, the need for an equitable result is not alone a proper ground on which equity jurisdiction can be claimed. Illustrative of the power of equity to provide relief unobtainable is its jurisdiction to rescind and cancel instruments. See CJS, cancellation of instruments, and rescission, section 7, and to issue injunctions, see CJS injunctions, sections 175 through 177 and section 250, and as shown in CJS reformation of instruments, sections 2 and 67, and CJS specific performance, section 3 and 130, and to reform instruments and to compel the specific performance of contracts. B, preventative relief. Quitamment. Equity may entertain jurisdiction to commission of anticipated wrongs. A class of cases requiring special mention, whether the jurisdiction depends chiefly or altogether on the necessity of relief obtainable only in equity, is that of bills, known as bills quitamment. whose object it is to prevent anticipated mischiefs which could not after their occurrence be adequately redressed. Bills cont'd lie where a person has reasonable fears of being subjected to future inconvenience by reasons of neglect, inadvertence, or culpability of another. There are writs of prevention to accomplish the ends of pecuniary justice and are designed to prevent wrongs rather than to redress them when done. Such remedy is looked on with favor and is to the discretion of equity court. While equity will not interfere for the purpose of declaring rights to prevent a possible controversy, which has not yet arisen, discussed super in Section 12, or where no actual danger to plaintiff's right is shown, it will interfere to prevent a multiplicity of suits, see info sections 38 through 41, or an irreparable injury to a freehold, or to protect subject matter of a controversy where there is actual danger, and it may be also so dealt with as to prejudice plaintiff's rights. A relief granted must depend on the circumstances. The ordinary form in which the court interposes the case of bill cont'd is by injunction and the appointment of a receiver. Next, Section 37, procedure as ground of jurisdiction. A, in general, equity may entertain jurisdiction of a controversy because of its superior procedural facilities. Inadequacies of a remedy at law may consist of an inadequacy of legal procedure, and with this in view, the court of equity, unimpeded by procedural obstacles existing in courts of law and better adapted through its superior procedural facilities to afford complete justice, may assume jurisdiction of controversies which cannot properly be settled at law. B, adjustment. Equity may assume jurisdiction of controversies involving matters of adjustment. Next section, distribution of funds. Where a specific fund or property is appropriated to or charged with the payment of various claims, so it must be administered for the benefit of all. Equity has jurisdiction to take an account of the claims and distribute the funds or proceeds of the property among several claimants. Such a suit may sometimes be maintained by a single claimant on his own behalf, but only where the charge on property is the nature of a trust. Next section, 2, multiplicity of suits, circuitry of action. Section 38, multiplicity of suits. Multiplicity of suits is grounds for equitable jurisdiction, but no plain and uniform rule can be stated as to when equity will take jurisdiction on this ground. It is frequently stated, the statutes sometimes expressly so declare, that equity will assume jurisdiction for the purpose of preventing a multiplicity of suits. The general principle being that the necessity of the multiplicity of suits in itself constitutes the inadequacy of the remedy at law, which confers equitable jurisdiction. Equity may take cognizance of the controversy to prevent repeated litigation of the same issue. However, in application of this principle, the diversity and conflict in the decisions have been so great that it has been said to be difficult, if not impossible, to reconcile the cases or to deduce them from a plain and uniform rule by which to determine the question, and each case must be decided on its own merits in the exercise of a sound legal discretion. The factors to be considered being the real and substantial convenience of all parties, the adequacy of a legal remedy, the situation of the different parties, the points to be contested, and the result which would follow if jurisdiction should be assumed or denied, and the particularity, the right of a party to trial by jury. The single fact that a multiplicity of suits may be prevented by the assumption of jurisdiction is not enough in all cases to sustain it, although the prevention of such a multiplicity is a persuasive argument in favor of the jurisdiction. To justify the interference of equity, it must appear that such an action will promote justice, and that all rights involved can be as well protected in equity suit as in the separate action. Where the case is not covered by any controlling precedent, substantial inconvenience to defendants, if jurisdiction is assumed, may overcome the convenience to plaintiff and justify a refusal to take jurisdiction, although a formal multiplicity of suits would thereby be prevented. Equity will not take jurisdiction on the ground of multiplicity of suits where there is no necessity for it and where the legal rules as a jointer of parties and the jointer or consideration of actions permit adequate relief in a single action at law, or where there, for any other reason there is no necessity for a multiplicity of suits to obtain full relief at law, or where a multiplicity of suits is not threatened, or by taking jurisdiction of a multiplicity of suits would not be avoided, or where the assumption of jurisdiction would tend to be the multiplication of litigation and the production of delay. Equity ordinarily will not interfere with the object as to save the expense of a separate action. The doctrine has no application unless the joinder of the several matters in one suit will really simplify and consolidate the issues. There is no avoidance of the multiplicity of suits by simply uniting them in one proceeding. The prevention of a multiplicity of suits is an independent and substantive ground of equity jurisdiction and not merely a make-weight where other equities are present. A right to either legal or equitable relief is sufficient. There need not be an independent equity in addition to the avoidance of multiplicity of suits to support the jurisdiction, although this ground is often one of several equitable circumstances which together support the jurisdiction. However, this ground of jurisdiction does not create a cause of action where none otherwise exists. There must be a prior existing cause of action, a right to relief, involving a multiplicity of suits before this doctrine operates to transfer the whole matter to the jurisdiction of equity for a complete determination in one suit. The jurisdiction being exercised for preventative purposes, it must be invoked in a time to have preventative effect. After a number of actions have been actually brought to issue, it is too late to maintain an equitable action on the ground of multiplicity of suits. Multiplicity of suits as a ground of equitable jurisdiction finds application in connection with an equitable right to relief against fraud, to contribution, see CGS Contribution, Section 25, and to an accounting, see CGS Accounting, Section 20, and in connection with other matters considered in this title and in an appropriate titles of this work. Next section, number of actions. Suits do not become of equitable cognizance merely because of their number. Multiplicity of suits does not mean multiplicity of suits. The number of actions which constitute a multiplicity of suits so as to justify or require the assumption of jurisdiction in equity is not fixed, but depends on the circumstances of each case. Next section, 39. Who may invoke jurisdiction? There is authority that only one who will be forced to bring or defend a multiplicity of action may invoke equity jurisdiction on such ground. The general rule is often stated jurisdiction on the ground of preventative of suits can be invoked only by plaintiff who would himself be compelled to bring or defend in numerous actions in question, that the multiplicity of suits against defendant which the plaintiff will not be subjected and in which he has no interest furnishes no grounds for its resort to equity. However, this rule should be limited to the class of cases where the multiplicity to prevent consistent of many controversies between the same persons discussed inference Section 40, and it has no application to the class of cases treated inference Section 41, where the multiplicity of suits relied on to support the jurisdiction consist of similar cases of action in favor of or against a numerous class of persons. But in such cases, the rule undoubtedly is that either party may invoke the jurisdiction, and the suit may be brought by one of the many on behalf of all. However, even in this class of cases, the general rule has been applied as the reason for declining jurisdiction. On the ground of prevented circuitry of action, discussed inference Section 42, the rule has been broadly stated that one may sue in equity in the first instance wherever, if there should sue at law, defendant may proceed in equity. Where plaintiff has voluntarily rendered himself liable to the multiplicity of actions threatened, he has no standing in equity to complain. A plaintiff may not come into equity for the sole purpose of preventing a multiplicity of suits which he himself has brought. Equity will not take jurisdiction to prevent a multiplicity of suits in order to loosen its own labors or those of other courts. The court itself has no equity. The equity must reside in the person filing the bill. Next, Section 40, multiple controversies between same parties. And I have a note here to see Section 34. Where controversies between the same parties involve common questions of law and fact, equity may take jurisdiction to avoid a multiplicity of suits. The earlier instance of the exercise of jurisdiction to prevent a multiplicity of suits were for the purpose of preventing one who had been defeated at law from vexatiously reiterating its claim. This jurisdiction arose chiefly from the inconclusiveness of the judgment and injunctions being granted to restrain repeated actions. Bills of this sort are one form of the class known as bills of peace. The jurisdiction was subsequently extended to protection of plaintiff from the necessity of reiterating a well-known demand against defendant, and is in a case of continued or repeated wrong. Equity also has assumed jurisdiction to prevent the prosecution of a multiplicity of actions by defendant against plaintiff, all founded on like facts and depending on the same questions of law, so that the decision of one will be practically determinative of all. On this principle, equitable relief has been granted in cases involving successive prosecutions for violation of statutes or ordinances claimed to be unconstitutional or invalid, successive action to recover disputes, royalties, and other like cases. However, jurisdiction has been declined in this class of cases until after the right has been determined at law, particularly where the right to relief depends on unconstitutionality or invalidity of statutes or ordinances. The jurisdiction has also been extended to distinct classes of cases where a complexity of controversies arises out of the same contract or transaction would require several actions at law for an entire relief. In such cases, equity may take jurisdiction and adjust all the controversies so connected in one suit. However, jurisdiction has been declined when invoked on this ground, at least where the various controversies do not involve common questions of law and fact, and it has been said that it should not be exercised except when necessary to protect plaintiff from litigation, which is obviously vexatious, where the parties to all the possible actions are the same, and all the actions involved the same question of law or fact. Equity has the power to grant relief, and this rule extends to the cases where the actual parties to the various actions are the same, although there are nominal parties who differ. Next section, prior establishment of right at law. At first it was thought that equity could interfere only after the defendant had been repeatedly defeated at law. The rule now is that plaintiff must first have established his right at law, but the satisfactory establishment of the right and not the number of trials founds the jurisdiction. Where the prior judgment is conclusive, the final as res judicata. There is no need for more than one adjudication establishing the right. However, relief has been afforded without awaiting a trial and judgment at law, particularly the case of repeated prima facie trespasses, waste, or where plaintiff's title is admitted or not controverted. Where the plaintiff's title is controverted, the bill may be retained until the title is established at law, and in the meantime, plaintiff's possession and the status quo may be preserved by an interlocutory injunction. Sometimes by statute, a court of equity is empowered to determine the legal right or direct an issue for that purpose, and even apart from statute, it is sufficient if plaintiff's right has been established in a prior suit in equity instead of at law. Under the code practice, in states where the system of law and equity are blended, it has been said that there is no good reason why relief should not be granted in the first instance by an injunction. Next, section 41, similar controversies with different parties. There's a very much diversity of authority to whether equity will take jurisdiction to avoid multiplicity of actions of controversies between a number of persons involving common questions of law and fact. As a general rule, the jurisdiction of equity to avoid a multiplicity of suits is restricted to those cases there would be otherwise be necessity for the maintenance of numerous suits between the same parties involving the same issues of law and fact, and does not ordinarily extend to cases where there are numerous parties and the issues between them and the adverse party are not necessarily identical. However, the jurisdiction based on preventing a multiplicity of suits has also been invoked, sometimes as a result of statutory regulation, where rights, simple enough in themselves, threaten a vexatious number of actions because of the great number of persons interested. This is one form of bills of peace. The earliest instance of bills of this character were brought by one claiming a general right against many persons to establish such right and thus avoid actions at law with each adversary. The jurisdiction is exercised, however, either to protect the right of one asserted against many or the rights of many asserted against one. Equity will take jurisdiction to avoid a multiplicity of suits where the subject matter of the contest is held by one opposition to a number of persons who controvert his right and who hold separate and distinct interests depending on a common source. The nature of relationship must subsist between the claims of the numerous persons cannot be stated with precision, although it is clear that such claims must be entirely distinct, unconnected, and independent. The fact that common questions of law and fact are involved in a number of independent controversies does not of itself support equitable jurisdiction to avoid a multiplicity of suits. It is often stated that the individuals composing a numerous body must claim in privity, or at least claim a common right in order to found the jurisdiction, except perhaps in the case of a continuing injury. Nevertheless, bills have been sustained where there was no connection among the different claims other than they were dependent on the same question of fact or law arising out of the same transaction. Other cases have held that such connection is insufficient to support the jurisdiction in the absence of an independent equity. The cases on this subject are very numerous where, on the one hand, jurisdiction has been assumed wholly or partly on ground of preventing a multiplicity of suits, and on the other hand, where jurisdiction has been declined when invoked on this ground. It is impossible to reconcile and harmonize all the decisions, even where they proceed on the same assumption of fundamental principles. The rule is most nearly approaches the result that the bill must relate to matters of the same nature and having a connection with each other, and that all parties are more than less concerned, although their rights with respect to the general subject of the case may be distinct. The matter is one within the sound discretion of the Chancellor to be exercised with view of substantial convenience of rights of all parties, which may be remarked is the rule governing the questions of multifariousness. The possibility of consolidating the matters for trial at law is to be concerned in determining whether the remedy at law is adequate and whether or not equity should assume jurisdiction. Where the common question of law has been judicially determined and all that remains is the application of that rule to each case, equity jurisdiction may not be invoked on the theory that thereby a multiplicity of suits will be avoided. Next section, prior establishments at law. Where the controversy is between one and a large number of persons, even though the right claimed is legal, no prior establishment, therefore, at law is essential, but the contrary has also been held. Next section, 42, circuitry of action. Equity may take jurisdiction in order to avoid circuitry of action, where instead of a complexity of controversies between two parties with respect to the same subject matter, the complexity arises from there being involved the several rights of more than one or more than two, each determining adjustment and each requiring at law a separate action. Equity may take jurisdiction of the suit to which all parties and therein adjust all rights and determine the whole controversy. Statutes have been enacted conferring equitable jurisdiction in this class of cases. Many cases of this character are in the nature of bills of interpleader. See CJS Interpleader Sections 2, 4, or involve trusts or other matters of equitable cognizance. The entertainment of bills to enforce directly a demand against the person ultimately chargeable, whether at law the remedy would be against one secondarily liable, has in some cases been placed on the ground of preventing circuitry of action. And the next section is section 43, accident, and that comes under the heading 3, accident and mistake, and I think we'll pick up there at the next one. It'll be on page 215. Yeah, so we'll go to the Q&A now. So
Q&A session started.
Anybody wants to get into the Q&A line, press *6, *1, raise your hand. Press *6, *1. 434, you're unmuted.
Yeah, Christian, this is Floyd. Hi. Okay, I got first of all, multiplicity of suit. Is that talking about how exactly, what is that talking about? Is it talking about one person bringing a multiple suits, or several people bringing one suit against someone, or what is that talking about?
Equity is going to take and simplify the matters instead of having many suits to occupy the court's time. It consolidate them into one.
Okay. Now, when it says that relief is granted by injunction, injunction is a term used in equity, right?
The injunction is equitable relief.
Pardon me?
Injunction is equitable relief.
Okay. It says the plaintiff has to prove the right at law. Now, what exactly, does that mean that you have to go in and prove that you have or that you have a remedy, or what does that mean?
I have to go back and review that myself, but, you know, there's other places in the book that we've read that actually said the opposite of that. So it's kind of like up for interpretation, I believe.
Yeah, because it says we've heard that equity cuts through all of that stuff.
Right. Right.
Okay. Now, if a man is if a flesh and blood man is bringing a case against a flesh and blood man, how would you handle that in equity? Because normally the courts would have that person come at you at law, and then how, if that was the case, how would you get into equity with that?
Well, that's kind of what I was just about ready to say. If you've got an action, you're coming at law to somebody, you really, you know, your first question there was hinging on that. Here you are coming at law, and how are you going to come against a real man on the public side at the at-law side? You can't. It's got to be a straw man.
Okay.
You want to go into equity on a man-to-man relationship? Okay. Are you enforcing a trust? Because if you're enforcing a trust, then that other man is obviously probably, say, the trustee, and a breach. And equity is going to treat him that when you're going to make a distribution.
Okay, I was wondering about something. A friend of mine that I'm aware of has he's being prosecuted by, I don't know if it's by the government or if it's by a flesh and blood man who is supposed to be a witness for the government, and I don't know if it's the witness that's prosecuting or if it's the government, but it's probably the government prosecuting using the witness against him. And I was wondering how...
I mean, you're not thinking. First of all, you got to establish, where are you? Where's this taking place? What's the jurisdiction? What's the venue?
Well, that's what I want to find out.
Public or is it private? Because
well, it would be public. They're trying to bring...
There is no real man in the public. It's all straw man.
Right. Okay. So if the government is using a witness against you, it's still straw man, right?
Still straw man, yeah. If it's in the public side, at-law side of the court, it's all straw man.
Okay, so then what he needs to do is he needs to capture that case on his UCC-1 and bring it in as a trust.
Do a withdrawal from the general deposit, which gave rise to the debtor creditor, gave rise to him being a defendant, pull it out of that venue, that jurisdiction, and redeposit in a special under trust.
Okay, right.
That merges the title. That extinguishes the debt.
Okay.
Case closed.
Yeah, it's an IRS case. Obviously, and they said he hasn't paid any taxes or filed any taxes for several years, and he's teaching others.
Send me a bill. That's all I care. I'm not going to sit there and argue with these people, because when you argue, you lose.
Right. Okay.
I don't owe the debt. Argue the facts, and you're dead. No, give me a bill that I can take and withdraw and do a redeposit. I'll extinguish the debt. Case
okay.
closed.
All right. Well, other than a couple of points that you brought out tonight, I guess that's about all I have right now.
Sounds like you're on the roof. Got a lot of wind out there or something.
Oh, that's my air conditioner.
Okay.
But we did have a lot of wind today. I mean, we got branches all over the place.
Sounds like they're through the telephone lines.
Well, that's just me. Well, I've been known to be windy before.
Any word on your other stuff?
I just got a notice today that they were asking me to make a payment, and but I haven't gotten my green card back because I made it, a special delivery. In other words, they have to deliver it right to that person that I named on the address, and so.
Did you go online and look up the number and see what happened yet?
No, but I can do that. In fact, I could do that because the post office told me that if I wanted to find out where it's at, just to go online, USPS, and then put that number in, the tracking number. Yep. So I'll do that. I'll do that. I'm glad you reminded me.
Okay, you have to press *6, *1 to get in the queue line to ask a question. Anybody? We got an open board, so press *6, *1 to get in the line. Raise your hand. 717, you're unmuted.
Greetings, Christian. This is David from Pennsylvania.
Hi.
Yeah, I've been listening to some of your audios and been studying this for about a month, and I'm trying to get up to speed. So I guess you've been on the air for a while now.
Yeah, probably about over 2 years now.
So I got about a month's worth of studying in, so I guess I'm a little behind the curve. But, okay, the question I have is I lost my home last February, February 2nd of 2009. And I see that there's a strong possibility of a remedy here. And I guess if this is applied correctly, I could actually retrieve my home back.
Either that or the proceeds therefrom, because it's from the original note, yeah.
Well, so I got this thing in federal court right now. It's on an appeal, and see, all my belongings are still there. And that's another court case. I'm trying to retrieve my belongings, so I'm not only out my home, but I'm out everything I own. So I didn't know if this would be a faster mechanism to get me back in my home versus trying to run out, I guess, the federal case and the local case at Superior Court on appeal.
Mm-hmm. So what do you got in there running now?
Well, in the federal court, it's a RICO action against 9 defendants, and they threw the thing out, appealed it, but I just think that's just buying time, but I don't really think I'm going to get a remedy there. So that's why I was sort of looking at this, trying to basically get a remedy, just to get back in my home.
They can't keep under common laws. They can't keep the house and the note at the same time. Did they give you the note back?
No. See, I didn't even know to request it at that time.
Did you ask for the note back or demand it back?
Okay.
Okay, so that could be an action that I could come at them with and demand that note back, or else give me the house back, because they can't keep the note and the house.
Yeah, at this stage of the game, yeah, they sold the house, and then yeah, they also kept the note. Yeah, because I actually really like to have the house.
And the next thing I would do then would be, you know, to get some kind of trust action going and claim the original note for the property and get that back, or at least ask for it back. You'd have to turn that into a trust and then use that as trust res and demand for the special deposit back.
Okay. Is there anybody, like in the Pennsylvania area, that could just help me get started on this to get me pointed in the right direction?
You might want to get on the Monday night call and ask to get under one of the head and trust ambassadors to get in one of the groups.
Oh, okay. Yeah, because I got some paperwork here. I sent an email. It's at christian@movingtitles.com. I sent you an email, but I never really got anything back, so I didn't know if you got my email or not.
Yeah, there are millions of people exposed to NTT now, and it's really taking off, and we're, you know, I'm only one person, so I can't answer everybody's emails. There's no way. I'm sorry. I'd love to, but I can't.
All right. Well, I didn't know if it was still a valid email or not. So the best thing what you're saying is get into the Monday night call. And
yeah,
then,
the best thing is calls. Yeah, because you know I'm on the calls.
Okay, and then you said get into the local ambassadors for this area then?
Well, there's trust ambassadors that are online, you know, and we're going to organize that a little better to where we got more of a group-wise, where everybody's under a trust ambassador, and each person has like 12 under them in a group.
Okay. Yeah, because I heard on the one audio you had, I guess, where you're actually trying to get with 12 ambassadors. Do you have your 12 yet?
I don't have exactly 12, but I've got, you know, about 9 or 10.
Okay, well, that's good. That's good.
But
how long?
The next thing to do would be to get on, you know, since 11/7 of 2009, any of your tapes, and go back over the audios, and because anything from 11/7 forward is all NTT. Get a hold of the tapes, the audios, and listen to those.
Yeah, because I listened to one. It was in February 26th of 01, and I listened to January 27th. Yeah, I listened to probably about 8 of them now. Actually, where I'm at now, I'm up to December 26th of 09. That's where I'm at right now.
Well, those will get you up to speed up till now, till present.
Okay. Okay, now, I guess I've been studying about where I guess you have to, I guess I got to get that certified copy of the Declaration of Independence. I got that information. I just have to call the lady. And then I got to
you know, that's the Declaration of Independence is for something we're going to claim the whole total account. You know, that's one process involving NTT. But on an individual case-by-case or an instant-by-instance, you could use NTT individually. It does not involve the Declaration of Independence.
Oh, okay. So in other words, I can actually do this as like a separate action just for the home.
Yeah, just like I was telling Floyd there with the party that he was talking about. All it is you're just doing a withdrawal of the general deposit that you've made, not knowing that you've been making general deposits all along. You're withdrawing that, and you're changing the nature and character of the deposit from a general deposit into a special deposit, and you're redepositing it back in as a special deposit under trust, and that really merges the titles, and it takes the lower contracts or the debt and extinguishes it in the higher, which is the security, the trust, and it extinguishes the debt as a payment.
Okay. Now, when you say changed it from a general to a special, now you're talking about the promissory note, or?
Yes, because your promissory note, when you made it out at the mortgage foreclosure, you gave them the promissory note as a general deposit. And that gave rise to the debtor-creditor relationship automatically by default, and you never knew it. Because you didn't know you had to express a trust. If you'd expressed a trust, it would have been a special deposit. But you created this general deposit. Now you got to withdraw it from a general deposit nature and redeposit it as a special deposit under trust, a trust deposit.
Okay, no, I still...
And that extinguishes the debt. That pays the house.
Okay. Now, would I still go through that exact same format even after they sold my home a year and a half ago?
Yes, well, I've changed in nature and nunc-pro-tunc all the way back. It made payment back when you presented them the general deposit, but now it was misconstrued to be a general deposit. It's not my intent for that. It's my purpose intent to be a special deposit, and at the time you handed them the note, what you did is you just reversed the whole transaction all the way back when you did it.
Okay. So then at that point, then they lost all standing to even do a foreclosure then?
Yes. See, it's been a trust all along, except they're waiting for you to express it. And the only way they're going to recognize it that it is a trust is if you do express it. Since you never expressed it to be a trust, therefore it's no trust. It's not a trust until you express it. You're the only one who can express it.
Okay, now is there actually someone that actually had success within the group as far as getting their home back by doing this procedure?
Not yet, not that I know of, no, but we're working on that.
Okay.
There's been cases that have been closed down.
Okay.
Yours is a little farther advanced, and you want to try and get the house back, but you quite possibly you could say, you could get the house back, but you might want to just settle for the amounts.
Well, see, the house is worth. The house is actually, I think, on the county records as far as valued. I think it's $286,000, and they sold it on the block for $167,100. So the house is worth a whole lot more than what the note was. The house is worth about $100.
Value is all for tax purposes on the public side. We're talking about equitable assets to discharge discharge on the public side, but extinguish the debt.
Okay. All right. Well, I'm going to get on the Monday night call.
At the beginning, when you closed escrow, that really paid the property right there. You just created documents under a debtor-creditor relationship, and that's what they foreclosed on.
Okay.
All this was because you never expressed it to be a trust.
Okay. Yeah, if I could actually have somebody that really battle test this and then give me like a little bit of a pointer exactly how to go through it step by step, but I'd like to jump on this pretty.
Get under the trust ambassadors because they're the ones that are going to be the ones passing the information through.
Okay. And that's Monday night.
Yeah, Monday night is the ambassador calls. Get on there and make an announcement to get under somebody.
Yeah, that's it. What, 10 o'clock? Okay.
Yes.
Same number here. Okay. So I appreciate it. Thanks a lot, Christian.
Okay. Okay, 201, you're unmuted. Anybody wants to get in the queue line, press *6, *1 to get in line and ask a question.
Hello?
Yes.
Hey, this is Bill, Christian. How you doing?
Hi, Bill. How's it going?
Yeah, good. Question: what relevance are the federal courts with respect to equity jurisdiction?
All courts of chancery have equitable jurisdiction.
So the federal courts.
If there's in federal courts, they have equitable jurisdiction.
Right. And the reason why I ask because the federal courts seem to have a greater latitude or do the federal courts have a greater latitude for equity than certain state courts?
Statutorily wise, under the statutory equity, that may be so because it's governed by statutory law, maybe. But pre-33 equity, that's going to be a different thing. That's on a private side.
Well, I was reading today that this particular author, Mr. Pomeroy, stated that the equity of the federal courts goes back to the revolutionary times. It was granted to the federal courts. It's the same status as chancery in England.
Okay.
So,
states, because back then it was state rights over the federal.
I'm sorry, I didn't catch that.
Back on time ago, it was states' rights over federal, and it was we the people over states' rights.
Mm-hmm.
So we are equity. We were equity, and now we got to get it back from the bottom. We got to switch it back around and get back on the top.
Right. I was just considering the fact that it seemed that it would be easier access into federal because of that particular precedent. That's why I was asking.
Oh, I don't know. That would have to be studied further to find out if that looks like it's more. You mean easier to get into a federal court for equity?
Yeah, because it's what I read was it didn't have the same. In other words, no state can pass a law to vitiate the federal equity, and if it does, it's not valid. So when I read that, I was thinking that the federal law, even though it's federal, has that particular standing, the court, and then maybe something to look at. Whereas we're having difficulty on.
That's statutory, and that's public side.
Correct. The thing is, though, that in other words, I'm just saying, it's like we could look at it either way. Let me rephrase this a little bit. So you're saying that under federal, it might be easier to get into the private, the federal, rather than the state? Yeah, exactly right.
Okay. That I don't know. I can't answer. That's one of those things we'd have to. Within time, I imagine we'll know more of these things.
And the reason why I'm thinking that way is because if everything is a mirror, and based upon the things you're reading tonight, so you read generally, usually there are two ways you can interpret it. So if it's a mirror, then, as you say, we are the equity. It's incumbent upon us to decide which ones to use and how and what language to use to create the energy to let the court know that we're in equity.
Mm-hmm.
So back to the Fed, I'm just saying that it's something that I didn't know about. I thought you could have a share on that.
That would have to be researched farther. I haven't seen anything that kind of pointed out that federal was more easier to get into than statewide, but you could be right. I don't know. Where are you pulling your source from?
John Norton Pomeroy, Equitable Jurisprudence.
Uh-huh. What's the publication date?
This one was 1830s, 60s, I forgot which.
Oh, okay. That kind of explains it right there. Yeah, at that time it's like that was before the flip-flop, and states were probably more over top of federal. Federal might have been more lenient. Now, the thing to do would be to compare at that time frame what has changed and how it's changed, and if that still holds true or not.
Right, and my thinking is that even on the federal side, we still have there are two sides. There's the
yes, but see what you're studying right now. If it's pre-33, you're studying private side equity, and
yes.
It's saying on the private side of that equity, it's easier to get into federal court. At that time, they was probably right.
Mm-hmm.
But now, since 33, everything's flip-flop. Now we got statutes and codes and stuff, and that now you got a public door you got to walk through to get to the private side equity. So you got like two doors to get through. You got to get through into chambers, but first you got to get through the federal. Now I don't know if the federal is tightened up more than the state since that time or not? That would be the next question to research out.
Mm-hmm. So you're saying that the federal judiciary would be changed by statutes.
Since 33, yes.
Mm-hmm.
Because now you got this public door to walk through to get to equity, which is in chambers.
Well, once again, isn't it possible to look at a statute? We can look at a statute as public or private. Depends how we choose.
It's like prior to 33, you only had one door to walk through to get into equity. You could choose the door. You either got into equity or you want to get at law. We only had one door to walk through. But now, since 33, you got to walk into a public door, and then once you get inside in the public side of the court, now you got another door to go through. You got the in chambers to get into equity. So now you got a double door. You got two doors instead of before you only had one.
Right.
And now the question is, has that been tightened up since then? That would be, and I'm thinking that it would have been, because they don't want you to go into equity. They're feeding you statutory equivalents like unclean hands, which is a statutory equivalent of he who does equity must be doing equity.
Right. So when do those maxims become statutories?
I don't know. You have to check each one. I don't know.
Well, can we write similar language that says something like that without using the same words?
Yeah, if I didn't want a multiplicity of public side case of cause of action going on with a in chambers action, then I would leave out, say, unclean hands doctrine, and just come in under maximum.
But I thought that was a maxim.
No, unclean hands doctrine is not a maxim. It's a statute and code.
Oh, really? Okay.
Maxim is he who does equity must be doing equity.
Right. And there's equality is equity, or equity is equality.
That's how confused everybody's been brainwashed to think. Here's this statutory equivalent, unclean hands, that's statutory and has nothing to do with equity, although it's based on equity. But you can get that at the at-law side, and that's the false equity, because that leaves discretion to the courts.
Right.
Or it was equity, that was it. You either had to be doing equity, or you couldn't ask equity to be doing something for you.
Well, does that still apply now?
Discretion.
Well, which maxim doesn't require discretion?
The equitable maxims under equity. There is no leeway.
Okay. What about it? What it says? Equality is equity, or equity is equality. Is that a maxim, or is that a statute?
Yeah, because you're limited to process, form, and procedure to get unclean hands doctrine through, where equity is going to run just on substantive rights, as you got to be doing equity to get equity.
So now we have rights, we have interests, and there are three things the three subject matters, right?
Right, title, and interest.
Right. Okay. Now, so those are the things that equity looks at?
Yeah, they kind of tie in, but equity's going to look at rights.
More so than title or interest?
Well, they kind of tie in, but if it references into those, yeah, it'll tie in.
Okay. And now equity is not concerned about the rights of the person?
All equity is concerned about the rights of the person, period.
So the distinction between in personam and rem and true equity doesn't exist.
In personam action is equitable, and in rem action is not.
Okay.
That law.
Got it. So then that in a way is like the keynote to distinguish the two, maybe.
Yeah, just about everything is really the duality of everything. And anytime you got a duality, you got segregation, don't you?
Sure, right.
That's trust.
Well, maybe it's separate but equal, right?
Yes, separate but equal. But anytime you got a duality, you got segregation. That means trust. And that means you're either going to be on one side or the other side, but not both sides simultaneously. So in a way, one side of it has been hidden because you're not in that side, you're on the other side. And you can be tricked into that side. That's the whole game. Welcome to trust.
How can it be separate but equal? They can't be.
Well, we're talking about title now. One has a limited value, which is really a stated value, and that happens to be the 9/10 possessory title, and that's the public side.
Mm-hmm.
Where the other one has an unlimited value, that's the 1/10, but it has no value. It's unlimited. It's valueless. That's where equitable rights are. That's equity. That's private. But if I took a piece of paper and slipped off 1/10 of it on the bottom, and I laid the two on a desk and asked somebody, which you can take one of those, whichever one you want. Well, which one do you think they're going to take?
The 9/10.
9/10 one. Why?
It's bigger.
It's bigger. Everybody is judging on quantity instead of quality, because the 9/10 possessory legal title, which is the bigger piece of paper, but that's the one that's got all the liability to it. The one you want is you want to go by quality, which is rights, and that's the 1/10. That's the beneficial interest. That's the real title. It's all about titles. When a trust comes in, it splits a perfect title into 9/10 and 1/10. But you're being tricked to go by quantity instead of quality. That's the big trick. And we're going by this, and we're looking at that thinking, oh, that's bigger. That's the one I want. No.
Right. So they're separate, but they're not equal.
No, they're separate, but you really can't compare them and say they're equal, because I guess equality, that's inequity. That's where your fairness and justice, and it really is.
Right. So I was just using that. That's like
yeah.
It's an impossibility in this case because they're two separate jurisdictions.
Yes, it's like God created Adam, but he pulled woman out of man. There was a trust formed right there.
Mm-hmm.
And they're both different. How are you going to measure the two? How can you measure one over the other? So you can't. They're different. They both came from the source.
So it's freedom of choice to select the public or the private.
Yeah, now you got age of majority. You got the ability to choose to act or not act and make a choice, one or the other. Welcome to NTT.
Okay, thanks. Well, thanks for clearing that up. I think you're probably right about the federal. It's probably just as difficult there. But,
yeah, or maybe even more difficult. I don't know. Anything else?
No, I just think that we look at the things you're reading out of CGS. One sentence says this, the other sentence contradicts that. It just seems that we have choices. Depends how you interpret it, how you read it. Yeah,
I think we have to remember this is all statutory because it's past 33. And this is out of 1992, so I have to take everything that I'm reading with a grain of salt.
Now, within CGS, when it gets to maxims, I don't know if you got that far, but are those statutory maxims or those, equitable maxims?
I think they're quoting equitable maxims there. When I scanned through it before, I didn't see any, I'd have to look at it again, but we'll get there.
So then, that being the case, within the CGS, you have statutory and you have private.
Yeah, that would be equitable maxim versus the statutory doctrine, like
yes.
unclean hands.
Right. But I'm just saying it's right there in the same book.
Yeah.
Okay, thank you. That's all I have for you.
Hey, Bill. Appreciate it.
Appreciate it. Ciao.
Next caller, Floyd, you're unmuted.
Yeah, speaking of maxims, I have the maxims of equity. As the maxims of equity evolved in Latin and eventually translated into English, as the principles applied by courts of equity in deciding cases before them. Now, there's 20 maxims that have been that are kind of traditional maxims, and among them, it says one who comes into equity must come with clean hands. So the clean hands doctrine is right there in equity.
Yeah, but that's where they came from, the clean hands doctrine, which is statutory.
Yeah, right. But it says, but equity, one who comes into equity must come with clean hands. And then it says, Bill was quoting equality is equity, and equity regards substance rather than form. So there's 20 of them that are laid right out.
And what's that out of?
Huh?
What's it out of again?
I got this off of the internet. I went into equity, secundum, corpus secundum juris, and then I just typed in equity, and it came up with all kinds of stuff.
So that came out of corpus juris secundum. What publication date?
I don't know, because it didn't really have a publication date. It was I had several choices that I could make, and I picked the one that was online, and it says the online encyclopedia and dictionary. So if you go online and you type in corpus juris secundum, and then that'll come up. It's called Fact Archive, and then just type in whatever you want. And I typed in equity, for example, and came up with all kinds of stuff. I got a kind of a kick out of this. It says, in modern times, law students have summed up the meaning of the maxims as equity taketh no shit. So all those 20 maxims were summed up.
Yeah. Okay. Anything else?
No, I just thought I would put that out there.
Hi, Christian.
Hey, Chris, how you doing?
Oh, I'm fantastic. I think this is the best I think I've ever felt. Well, just in the last year. The papers that we've been working on, I've just absolutely just floored with how effective they are. We haven't had any results yet, but I did go ahead and do the protective order, and I went ahead and did that other letter to the federal judge, the chief justice of the local area here, and gave him a copy of the papers that we've been working with, and so that's out, done, notarized, UCC'd. The whole thing is done and mailed as of today, and this is my 7th case that I've processed with this paperwork, and every time I process this, I feel better and better and better. But the question that I've got for you, you have to excuse me, I was running from behind the back of the house here. The question I have for you, how are you feeling about a dual attack, as long as we don't commingle, like saying filing criminal charges against these people for forgery, counterfeit, and that would be on the public side. And on the private side, here we are addressing the Chief Justice of the federal court on equity on the private with papers to go ahead and close out the trust. How about if we were to have two different packages, two different formulas that we can function with that would complement each other without commingling, and have that as our plan of attack with these, well, in particular, the mortgage companies. Credit cards, yes, but mortgage in particular. How do you feel about that? And the last part of that question I wanted to ask you was, the unclean hands doctrine is one set of doctrines, but how would we address it on the public side, that there does exist without commingling? How can we do a presentation that there's two sides of the story for each case? How can we keep them uncommingled and have two running cases, public and private, just to I mean, this is going to come up as an issue somewhere down the road for a lot of people. I already know that. Yeah. Especially the people that have done maritime liens, people that have done the administrative process, people that have got default judgments, people that have got Rule 55, certificates of default judgments on the debtor-creditor side. So there's a whole bunch of stuff that needs to be talked about, and I don't know if you want to talk about it on this call, but I just popped it off and just wanted to see if you had a response to any of the stuff I just gave you.
Well, it's like I feel smooth, or I feel rough, or I feel, that's how I feel, because I feel with my hands.
Mm-hmm.
But anyway. That was a joke, but anyway.
I'm sorry. I was engaged. I've been having jokes all day long. I'm sorry. I was engaged with really coming to bear on a lot of these cases that I'm dealing with, that we've got such a presentation to win on the public side, and I really feel that there's a proper place for all that. And, of course, this kind of led into some of the UPU language of being the maritime area of the public and the private and the maritime law stuff. And what I'm trying to do is I'm trying to get it in my intellect. I'm trying to get it adjusted to where we can actually harvest successes on each of the sets of laws and actually be a master of all of the laws and have equity and trust law to supersede it all. And what I would like to see our students to learn is to get familiar with all the different laws so they can handle any situation, given thing that's being presented to them, but in any case, we have the equity and the trust law that supersedes all of it. Therefore, they're being educated with a safety net of the trust and equity. So that was kind of my thinking in this last couple days, is that in the education that we're going to make available for people that are interested, is that I really truly believe they should be familiar. They don't have to dive into it and take off in a tangent, but they should be familiar with all these other laws to know how to handle themselves and just have formulas in their heads that allows them to understand debtor-creditor, admiralty, and you've got the statutes and regulations and codification. And it was just kind of like something that I wanted to talk to you about, and I don't know if this is the right forum, but I'm going to put it out there and let you kind of make an answer or tell me to
It really hinges on what you said there. Not commingling both sides so that you breach your own trust. That's the trick. And it might be maybe through a multiplicity of suits in some way, or maybe we might have to keep each suit separate somehow to it's either going to maybe be equity or at law or one or the other, or maybe we can combine them somehow. I don't, it doesn't seem clear just exactly yet, but I'm sure it will be.
Well, one of the interesting things that happened on a different forum this week is there was a lot of talk about the difference between the maritime laws under the UPU and how that supersedes pretty much the kit and caboodle outside the fact that we've discovered that trust and equity law supersedes that.
Right.
And one of the things that was brought up is that there is a private and there is a public. Now, if that's true, if I'm thinking this thing out properly, that means the private side can actually be where we actually can do the interface with equity and trust law on the maritime set of laws under the UPU.
I'm not exactly sure if that could be that way or not.
Well, anyway, I just wanted to put it out there. I'm stipulating I really feel that there's a future for us, and there's going to be some discovery. I've got a couple interviews with other people other than the one that we had this last week on the UPU issue. But what a major success to be able to get exempt from the postal zone of the United States Corporation and to have some relief. That looks very promising, and I am intrigued, to say the least. And this other gentleman down there in, Utah, that has been teaching UPU stuff, has discovered in other words, when you do get a registration number as exempt from the U.S. corporation, that actually becomes a security of which is bonded by the U.S. Treasury, of which at that moment you have the opportunity to go ahead and tap into that and set up a checking and a credit card situation, a little bit like what we're doing here. And I thought to myself, wow, this is really interesting that all this stuff is coming up on these different levels. It's going to be interesting to see how it's all going to pan out. But I have another interview.
Anytime you've got a security under Article 9 or a negotiable instrument on Article 3, or anytime you're doing any kind of negotiable debt instruments, that's all public.
Well, it was my understanding that the quote-unquote that I caught that backed this is that there's the private side of the maritime laws under the UPU, completely exempt from governments in totality. That was the quote that was said, and I'm just like, really?
Here's if you picture in your mind, you draw an account, an upside-down T. On the right side, you got the plus, you got the assets over there. That's the private side. Equitable assets on the private side. Then on the left side, you got the liability, the minus side. That's the public. So you got trust right there because you got a segregation, got two sides. But here's what everybody doesn't realize. On that left side, what you're going to do is you're going to draw another upside-down T within that. And there is your corporate private side and corporate public side, all within the bigger public side. So is that private side on the left, that little one, is it public or private? It's public.
Well, I think that for everybody that's on the call, I think it's important for us as individuals with different various, ways of looking at things here is that it would probably, well, for me anyway, it benefits me to know all the different laws and how they all fit together and how they can actually be worked out.
Yeah. That's everybody's problem because everybody thinks the law is the law and it's all one thing.
Yeah, and what
common law is thing out there. No, if you don't have common law plus equity, you don't have a balance. So everybody thinks we want common law, No, you got to have common law along with equity. If you don't have equity to balance common law, you got some bad law, buddy. You got some very strict stuff that you don't want to be. There's no way out. And then there's the admiralty, and then how it all relates, and then taking into consideration about the flip-flop and all the falsenesses of what was real before, but then that was all held and put in trust. It still exists, but it's on the private side, and all. A lot of this stuff is complicated because of all the convolutedness of the whole thing. But that's meant to hide it, and it does it very well.
Yeah, and I have to say that maritime law. And what I've been following back to the UPU on my own investigation proves the same. Is that they hide this stuff. The private side of maritime law is so well hidden that I think it's only because of the UPU and the manual that came out of the UPU that has shown me some of the private side with no conclusions at this point. But I think that coming down the pike here in the next week, 2 weeks, maybe a month, that there could be some kind of implication or some kind of an application, either way, of being able to use trust and trust language dealing with maritime law.
Yeah, trust is really in the center, and all the other agencies and laws come out of it, I think. It's like
I think so.
Three-dimensional ball, but in the center, that's trust. And then the other laws are coming out to the surface.
Yeah, because you remember the conversation we had with the group this last week about, equity law and trust deals with relations, and that means that it has to be the hub, because how can any other existence be if there's no trust relations or treaties or anything else that's substantiating kind of a commerce or some kind of a communication or any kind of an agreement or contract or maritime lien or anything else?
Yeah, so what hangs this all together, the glue that brings it all together, is the trust.
That's the thinking I'm coming to, and this is where I'm intrigued with the maritime information that I've received this last week. And I don't know that much about maritime law, but if I was to gauge importance, I would say trust, equity, maritime, and then it goes on from there. That's the way I see it, because maritime deals with communication, treaties, commerce.
Yeah, commerce, yeah. It's all commerce.
These are the unification factors that puts all countries together in some form of an agreement, and whatever contractual or trust relations, this is your interface that it's almost like you've got equity and trust that manifest into commerce and communication and treaties.
Yeah, so, all together, yeah.
Anyway, it's been one hell of a week. Man, I have been flying by the seat of my pants working with papers and whatnot, but I'm so proud, once again, I'm so proud of being part of this group. And we have so much interest out here in California right now. People are coming to me, it's like a candle with wax right now, Christian. People are coming to me wanting to know this stuff, and all I do is try to get them on these calls. We could have probably half a dozen to a dozen people right now from California on this call. I don't know if they took the opportunity to do this, but they're very excited, they're intrigued, and so yes, we've got the flow going in the right direction right now with the trust stuff. So
yeah, it's really catching on more than what people realize, I think.
Yeah. Anyway, I didn't want to occupy the phone. I just wanted to ask you and think about some of the things that I said about the maritime, the private side, because I think coming down the pike with the UPU and the Form 101 and some of the things that were discussed with our friend Keith, and some of the things that were discussed with Paul out of, Utah or somewhere down there, we're going to have, here locally, we're going to have a presentation, a private presentation, and I will record that, and I will make sure that you get a copy of that, because I think it's important for us to look and see where other groups have progressed and see how we can relate and or pick up confirmation or acknowledgement of certain areas that leads us back to the trust and equity. So.
Yeah, I'm sure we're touching on different areas, but coming at it from different directions, but we're all talking about the same stuff in certain things. So, yeah, there's an relation between it all.
Well, personally, I just want to become a master of all this stuff. You know, I want to know exactly why this, and this led me to this. And I really would like to teach my students out here in California the reasons why equity and trust supersedes all of it, and its lineage from there falls into certain categories, and why by treating this over here in the public and treating this over in the private is going to be ultimately how you will get your results and be effective in enforcing with your powers. So I think that that's kind of like what I'm thinking, and of course we can continue this longer, but I'm going to let you go back to the group and ask new people to ask questions.
Yeah, I've been trying to come up with the same thing, what I would call a unified theory on how to bring all this stuff from A to Z together.
We're getting close. Believe me, Christian, we're getting so close.
And I really believe that the glue that holds it all together, or the foundation of it all, is really the trust.
No, I agree, because, you know, when you look at all the maxims, in fact, the gentleman that was here on the call a little bit earlier talking about the maxims, it's all about relations. You know, why would anybody have any relations? There has to be a barter of fair trade and or some kind of an agreement of sharing or exchanging something from one sentient being to the other. And when you look at relations between states, when you look at relations to the DOI, when you look at relations to UPU, these are different relations. The UPU does not have to answer to any government. It's vice versa. Every government that is either outside of the UPU has to be a symbiote relationship with one that is in relationship with the UPU, or they have a direct relationship with the UPU, which is exempt, therefore they have an easement, therefore any time that any other postal zone under the UPU wants to communicate to the other postal zone, it has to do it under survey and easement, of which is almost identical to trust. It's all named out in what is the indenture, what is the treaty, what is the agreement, what is the relation. This is what it's all about.
Yeah, now what would be the missing element?
Missing element, would that be the...
Because all these relationships, they all look alike, but they're usually missing one or more elements that doesn't make it a trust, but makes it some other kind of relationship or relation.
Yeah, no, I agree with you, and that's the reasons why by learning equity and trust language is that you make sure that in any type of relations that you have with anything, I don't care if it's your next door neighbor or whatever, is that you include all the elements to a trust.
Yeah, well, that's what we're focusing on here through NTT, which is relationships. We're learning how to distinguish the different relations or relationships and then discern what is missing and add it, turning it into a trust.
Yeah, and you know, one of the best persons that I know that have ever put structure together is you and Jacob. Between you and Jacob, both of you guys have allowed me in a very, very interesting neutral zone of listening about the relationship with God and creation and manifestation and our part in what we play in that trust. And I really got it. I came online with that just fairly recently, and because I had a lot of objections to a lot of the calls that we used to have, that people would come on and they were Bible thumpers. I didn't really care for that too much because I believe in God, I believe in manifestation, and I do have a direct relations with God, and I know that I'm here to do this kind of work to assist other people that need assistance with this stuff. So I know my relationship space, but between you and Jacob, both of you guys restructured kind of a neutral space for me to get back into a fold of addressing if you want to call it the Jacob's ladder, or if you want to call it the pecking order of priorities of trust, God is certainly on top. And my relationship with God, that is a singular event. And then from there out, it falls into my relationship with the planet, my relationship to my body, my relationship to society. What is it that I am to fulfill as a contractual agreement with God, being in this manifestation at this time? All these things fell right into place in the last 6 months after speaking with you. And there's other people. I just didn't, but Jacob and me, we sit there and talk for hours at a time, and it just pours forth that, this is how it's set up. It's your direct relationship with the Creator. That's number one. And it follows the Bible. And so I really did have, I had quite an enjoyment to have that is being brought back into my psyche, and the way I compose my documents and whatnot. And it makes a lot of difference, especially with the land patent and the notice of intent to preserve an interest documents. When you start naming the Creator it takes it completely and exempts it right out of commercial standards. And I actually like that very much.
Okay. Great.
But did you have any last comments? I feel a little empty on the idea of being able to create formulas on the debtor-creditor side and have that be not commingled, but a complement to what we're doing with the trust and equity and the private.
How do you mean? You mean the two sides?
Well, we got the unclean hands doctrine, but I was thinking, okay, so say for instance, somebody has, they have absolutely no way to validate they're coming at you, and they trespass you, they trespass your property, they trespass your life, and they're just plowing through you, and this is what they do to almost every individual. Well, because of the private side can't be commingled with the public, we need a defense to offset these criminals that are running the attorney's offices, the real estate offices, the banks, the reconveyance offices. All these people, they're like the Borg off of Star Trek. They have absolutely no conception of rights. And when we're talking about rights on the private side, we're actually evading how we're going to handle these criminals, and I'm going to call it criminals because that's what they're doing. These are felony acts that they should be thrown in prison for. When they walk onto your property and they have absolutely no authority to do so, they just did a criminal act to do commercial value on your property. They brought the public in on private property. So they have encroached, and I want to be able to have a formula or an arsenal that we also cater to or at least address. I mean, if you're willing to, I know that you want to stay and you're adamant with the trust stuff, but we're going to have a whole lot of things to address that is still going to happen to people. That we have.
We've got two jurisdictions, we've got two realms, we got public and private. But we're always getting sucked into the general deposit, into the public realm, and that's where we're getting adjudicated, and that's where they're hammering us at. But, that works the other way, too. They could get trapped up in the private because they breached the trust.
Yes.
But we're just not administering or adjudicating justice from the private side. They're getting us to walk into that public realm, into the trap, when we need to get them to walk into the private side.
Okay, that's good. That's a good response.
And I think that could be done through trust, through the equitable side of trust.
Well,
our remedy is chambers in equity. There is no remedy, no adequate remedy at law on the public side.
How did you feel about those documents I gave you that are the instructions to the federal judge, the Chief Justice?
Okay, I haven't got to them yet. I'm still working on the CC template.
Okay, because I made it so gentle. The first part of that was addressing that because he is a judicial public witness, I called upon that aspect of him as a neutral party to keep those documents in safekeeping for future use if and when the banks fail to execute their duties and obligations of their said office under trustee of that trust. Therefore, at that time, these papers could be called forward under Rule 55, which would give a certificate of default judgment that these guys failed to execute their office. Therefore, it could be handled on the private. It could be completely separate from the public, that the judge signs off on a Rule 55. And it doesn't have to be in the language of the Rule 55. He's looking at the papers of where there was a presentation for the mergings of the titles. Therefore, after 14 days, they failed to execute those papers. Therefore, they're in breach of trust and could be held liable for the damages and injuries because of that.
Right, yeah.
And
So
the judge having those papers...
going to rubber stamp the process as being completed.
Yeah. In other words, you have your third-party witness, and when they say third-party witness, they're talking about a public offices and public officials. And anyway, I'm real interested in finding out what your take is on those papers that I put together.
Well, I'll probably be finishing up the other one I'm working on. So.
And then I reworked the protective order, completely reworked it. And it's as smooth as a smooth operator. And I'm sure that there should be some other things put into it because I value and respect everybody in the group to do a look-see and add their comments and whatnot. But I reorganized and presented it where it blended right in with the instructions to the judge to hold the papers in safekeeping as a public official witness on the judiciary, and therefore I will give him further instructions to act upon it if there is a default sometime after 14 days.
Mm-hmm.
So that was how it read out. They both blended together. They both enforced each other. As far as I'm concerned, it came out real well, but I'm sure that there's going to be quite a few other words that need to be added, and it was under emergency reasons why I went ahead and cranked those out.
Yeah, I remember you talking about them, and it sounded good, but I didn't get a chance to look at it yet, so.
Yeah. Anyway, I can't wait to hear back from you on those papers because, well, we'll see. We'll see what you got to say about it.
Okay. All right.
Anyway, I'll let you get to the next person. Thanks, Christian.
All right, Chris. Appreciate it.
Bye-bye.
All right, next caller. Floyd, you're unmuted.
I forgot. Oh, I remember. Yeah. And what Chris is talking about, Kristen, equity looks through all of that stuff, right?
Through the form, process, and procedure, right?
Yeah.
Those looks and
so, if we're equity, then what we can do is whatever they come to us with is put them into trust. Isn't that right?
I think that's the only way we're going to get a remedy is if we put it into trust and make it work out of equity.
Yeah. Well, you know, when you said take the upside down T and then take the left side as public, the right side is private. Put an upside down T in the public side, then that's a trust within a trust. That's a public trust, right? And that made it very, very clear to me all of a sudden. That was one part that I could never quite get clear.
That's why I was
that's a good scenario. Anyway, I think that's well, I don't know. I don't know exactly what Chris is doing, but it sounds like he's awfully busy with it anyway. So anyway, that was only what I wanted to bring out, was because if we're equity and we do equity and we bring everything into trust, I don't see what else we really have to do. Oh, there was one other thing that I was going to ask. What was it? Yeah, I guess I did forget that part, and I wanted to find out. Oh well, I'll think of it later, maybe. Okay, that's the only point that I wanted to make.
Right.
Okay.
Next caller, you're muted.
Oh, yeah, this is Bill again.
Hey, Bill.
Yeah, what Chris was saying, did I get that correct, that you were agreeing with him about the maritime and the equity? What was that? I didn't quite understand.
I might not agree with that, but what I was agreeing with, yeah, some of this stuff is well, it's like the trust is the glue that it's making all this stuff fit together. It's at the core. And he's working on some stuff that the documents that he's working on, I think it was making reference to that.
So then what I thought I heard him say was that part of the puzzle, the center is equity and maritime, because maritime supposedly is tied into the UPU international jurisdiction.
But see, when I look at maritime, maritime is delivering commerce, and commerce is all commercial. And if it's commercial, it's all public.
Right. Now, we have public trust, and we have private trust.
If UPU is admiral or maritime, then if maritime is commerce and commerce is commercial and commercial is all public, then that means that UPU is public.
Isn't that a private side to the UPU?
But there's that little upside down T in the public side forum that they say is private, but it's still in the public side. It just looks like it's public, or it just looks like it's private.
Right, okay.
It's a private side corporation and a public side corporation, but it's still corporate and it's still in the public. It's on that left side. It's in that big one on the left side under the public side, but within that public side there's another sub-T, and that's the corporations, and they got a private side and a public side, and that little one inside that public. But is that private side, what side's it in? It's in the public.
Right, it's in the public.
So is it private? No, not really.
Is it quasi-private, quasi-public? What is it?
Yeah. If it was really private, it would be on the right side. It's not in the right side. It's on the left side.
Well, it seems like it has to be on the left side to manage the volume of activity.
Yes, because it has to be an equal to equal itself out, so it exists in nothingness. It zeroes itself out.
So then the entire concept of, like you say, maritime is commerce, and that's about it.
Yes, because the equating was that UPU is maritime. If maritime is commerce, then it's commercial and it's public.
Right.
Here's a real test. If we're using anything that is a negotiable debt instrument, which consists of liens, bills of exchange, any negotiable instrument, that's all negotiable debt instruments. If we're using negotiable debt instruments, they're negotiable instruments, and it's all public. The only thing that's not public is non-negotiable instruments. How many of us use non-negotiable instruments? Equitable assets. So if we're using negotiable debt instruments of any kind, it's all public. Now, what are they using for commerce?
Negotiable debt instruments.
Using negotiable debt instruments? Yep.
Right. Now, a bill of lading, that's a commercial term?
That's an article, what, 3 or 4 or 5, right? Bills of ladings, or 7, I forget which one it is. Yeah, because it's for the transfer of goods.
Right.
And those are negotiable.
Well, I thought a bill of lading is just a list of stuff you have on your cargo, or your, what you're going to send out. Yeah, because that's going to be something I can have this listing of value under commerce, and that makes it taxable. It's making it limited. Well, now, could that be a trust res?
It could be. But when I cross it over and put it into trust res, then I'm not really talking about a value. I'm talking about a thing. So what I'm doing is I'm withdrawing it from the public realm and putting it back in as special deposit under trust. And I'm changing its nature and character. So it's no longer something of value. It's an equitable asset. I've withdrawn it from that public realm and deposited it into that private realm.
So then, in a way, that's why the public realm doesn't foster the private, because it's not consistent with the flow of commerce.
Yeah, it can't. It can't. They can't be commingled. If it does, you breach the trust, and that's what the statutes and codes are for the punishment of the breaching of the trust when we commingle it, whether we cross it from private to public or public to private. The statutes and codes exist on the line for the purpose of enforcing the segregation and the punishment for crossing the line.
Mm-hmm. Because if more people were doing the equity, it would could have a devastating impact on the commerce.
Yes, because that's the doorway that limits it, because it doesn't commingle each one. But you can get a remedy through that.
Right, I got you. So on the public side, really, it's not about remedy, it's about commerce.
Yes, because on the public side, the God on that side is commerce. Commerce is king over there. All the statutes and codes are for the purpose of speeding up commerce. We're worshiping commerce. That's the God over there. And we got to stop messing around with debt, because we're worshiping the debt. That's not worshiping God.
No. It's a false God.
Yes, a false God. Commerce is a false God, yeah.
So now, as on the equity side, though, it's remedies, but we would reduce the debt by taking, say, a bill of lading that has a value, and requesting that
Well, we take the debt, we put it with the equitable asset, and we extinguish the lesser with the greater.
Right, so it's just extinguished, but there's no actual transfer of currency or species.
Right. Nothing gets commingled.
Right, so what's happened, though, that the debt is being reduced.
Right. That's the only way you can reduce it. And here we thought we were reducing the debt with our private bonds and all this stuff we were doing and set off and all this other stuff. No, that's just creating more negotiable debt instruments. That's all for commerce. And they loved us for it. They never said anything. All we were doing was pumping up the national debt more and more and more. And we thought we were doing a discharge or a set off and reducing it, and we weren't.
So
they loved us for it.
So I mean, this gives me great clarity. So this is the real challenge, is to get over there into equity, to do what we have to do, and the minefield is, the statutes and codes.
Yeah, the real men and women are in equity. They're in the private, but their minds are brainwashed into the public.
Mm-hmm.
They're living there in their minds.
You know, it sounds like it's a very seductive thing, because, you know, we were talking about equity, maritime and the UTU. You know, we get all excited about all this stuff, but really, like you say, it boils down to just commerce.
And it just two things, because it's just two things with a different leaf face on it, and really it was the same thing all along. It all boils down to just two things. It's been segregated and divided in half. The perfect titles have been split. Right. And we've got to start focusing on looking at the titles. Which one do we have? Do we have the title, or do we have the possessory title, the legal title, which is in the public?
Right. Well, that was a good experience for me. Thanks a lot.
It all comes down to the title issues. If we start taking in titles, a couple nights ago on the other call there, the fellow came on. He was on there for one of the few times he's been on, and he brought up a question about, I forget exactly what the question was, but I was thinking, you know, if I had brought up the issue of the titles, I think he could have seen very clearly about what we were talking about. It would have made it, you know, I think his understanding he would grasp that. The fact that the 9/10 title is the legal title that's in the public, but the 1/10 is really the one that controls it all, because that's where that 9/10 title is supposed to go to. It's supposed to go to the beneficiary in the end. But that the titles have been split. And the only thing that you can see is the quantity, but you're not thinking about the quality. It's the quality of the titles versus the quantity of the titles. And we're getting trapped up in that thing.
Absolutely.
And it's all about the titles. And we can merge titles under trust. And we're not abandoning anything. We're taking it out of one realm and putting it into another. How could that be abandonment?
Well, you don't.
The debt with an asset, an equitable asset. It doesn't exist anymore then. Is that abandonment? That's not abandonment.
No, you made it go away.
Yeah, it totally disappeared. It doesn't exist on either side.
Abandonment would be a negative action, whereas making it go away, I would call it a positive action.
Yeah, the only thing I think would be an abandonment if I put something in trust and totally walked away from it and just forgot about it, never touched it again forever. That would be abandonment. But really, that would be foolish, wouldn't it? Even that isn't good for asset protection.
No, it's not.
So I think that's abandonment, is applying it to trust is totally a misconception on somebody's part that they really don't understand what we're talking about here.
Well, that's good insight. I didn't quite see it that way.
Yeah, it's good to hash this stuff out on the calls, because, you know, if we start talking about it in different ways, still coming at it from a different direction, but still focus on the main thing, then if we see it from different sides, kind of like in a three-dimensional view, now we get the total picture of it. Because I can only see one side of an orange when you're looking at the other side, and I can't see your side, and you can't see my side.
Exactly.
But if I switch positions, and I can see your side, and you can see from my side, and you see what I couldn't see from your side.
Well, I mean, I guess that was a valuable contribution that Chris made this evening.
Okay.
Thank you.
All right, Bill. Appreciate it.
Peace.
Jacob, you're on.
Hello.
Hey. How are you tonight?
Hello.
Hello. Go ahead.
I'm okay. Can you hear?
Yeah.
Can you hear me?
Yes.
Okay. I was thinking a lot. Yeah, I'm kind of in a super remote location at the moment, and I'm just barely getting a little bit of a Wi-Fi from area, but I was wondering if you could walk through with a theory that seems to be becoming a more valid premonition as I dwelled in it, though, and it's maybe there's like in I know you guys don't like to talk about spiritual things and stuff, a lot of people, but I think there's no way of getting around what we're faced against in the spiritual realm, because I think the physical realm that we live in is mirrored by what happens in the spiritual realm first. I have plenty of evidence, and I won't get into it, but what I would like to do is talk about the hierarchy of creation mirrored by the hierarchy of jurisdiction. And it might be that jurisdiction, if we're at our house, you know, we're in the city, and we're at a address that's a lot and block description, and then that's one jurisdiction. And then when you start getting into banking, and they take that house and they move it to the county, now you have another jurisdiction, the county jurisdiction. You've got the county register there that gives it a QSEP number and registers it as a bond and securitizes it through the insurance industry that's partnered with the banking industry at the moment, and they move it to the state. And they pull state bonds off of it to finance the states. Then they move it to D.C. for the federal bonding. So there's a city jurisdiction, a county jurisdiction, a state jurisdiction, a federal jurisdiction. Then it appears that the Federal Reserve has a jurisdiction all of their own. So there's a Federal Reserve jurisdiction. Then you've got these investors who are outside the U.S. jurisdiction in international jurisdiction. Now we have international jurisdiction. So I was wondering what you'd think of this. So as Chris might call it a ladder of jurisdiction. And maybe there's trust in each one of those jurisdictions. As we were talking through with a bunch of guys this week about the survey compact that allows men to travel in these jurisdictions. And so I thought that, maybe, like the...
Yeah, you're kind of breaking up there. But still there? Oh, he dropped out? Well, let me address what he had to say first, because the jurisdictional issues, what I see is in the beginning, God created the heavens and the earth. The heavens was the unlimited beneficial title, which had no value put on it. It was valueless. It was unlimited. And the universe, or the earth, was the other title that was created. It was the limited, or the one that had a value. So that was the 9/10 possessory title, the earth and the universe. But the title to the heavens was the 1/10 beneficial interest. Now, which one is the controlling jurisdiction? Only the beneficiary has the right to take. And he has the use of the fee that the limited owes the unlimited. That's the way it worked, and that's how jurisdiction is. But if you compare that today, they're trying to make it work that way, but they won't let you work it that way. And that's what we got to correct. So that's my answer there. The jurisdiction is really with the beneficial title, which is the unlimited title, which is the duty that the limited title owes to the unlimited title, the beneficiary. But they always want to see it that they're beneficiary instead of you being the beneficiary, and their thinking is wrong. They got it backwards. But that's the way things function in that realm, backwards. So the jurisdiction is really in the unlimited side in equity. You set the jurisdiction, you set the venue, you are equity. We're just chips off the old block. We were made in the image and likeness of God. So, next caller. 972, you're unmuted.
Hello, how you doing?
Good. Marshall.
Yes, sir. How's everything going?
All right. Good. How have you been?
Been all right. Same old everything. Studying and trying to learn. That's about it. I heard you say something tonight. That there was a chart that you were going over, and you were just speaking about it a little while ago. Was a circle, then a private side and the public side, but it's really public. Like, what were you going through?
I was just taking like a sheet of paper. You draw an upside down T.
Okay.
And the right side is the private side. That's the plus side, the asset side, the equitable assets. Okay. And the left side of the T is the minus side, the liability side. That's the public side.
Okay.
So right there, you got segregation of two sides. You got a trust.
That's the trust.
Public and private.
I guess I'm specifically speaking about is, I believe you said there's another circle.
Yes, I was just going there. Now, on the left side, on the public side, you draw another smaller upside down T within the left side of that other T, the bigger T.
Okay.
T within a T on the left side.
T within a T on the left side.
Smaller T on the left side of that smaller T, that's the public side, and on the right side of that smaller T is the private side, but that applies to corporations. So it's a corporate private side, corporate public side. So now you got a corporate private side, little T, but where does that whole private side rest? It rests on the public side, on the left side of that bigger T. So my question is that public or private? It's public.
That's public, exactly.
Yes. Yes.
That's definitely public. All right, yeah, I heard you. I was listening to you explain it. I just couldn't get it inside of my brain. Now that I got it down on paper, now I can actually see it now and see exactly what you're talking about. So now, that plus side, that private side, the real private side, I guess.
On the big one.
The big side, exactly. That's where equity exists, and that's where we need to be, on that side.
Yes, we're coming up with a little diagram on how to and on that right side, there's like land all the way across. But the land across. And there's like a cloud of equity on the right side, and then the man stands on the cloud of equity if he's in trust.
Okay. I'm actually
You'll see it. Probably when we get it done, it'll be coming out here shortly.
Okay. Cool. All right. My next question. I'm trying to get something straight in my mind as far as the doctrine of clean hands. Now, everywhere that I've researched as far as equity is concerned, that doctrine of clean hands, he or she must come to equity with clean hands. It's like it's everywhere, but if tonight I heard you say something different, that it's a doctrine and then it's actually an at-law doctrine.
Yeah, because you put that on the pleading as a cause of action in your at-law pleading. You put it in there, you go unclean hands.
So, but that would be for an at-law pleading, but what about a bill in equity?
Yeah, then we take that at-law clean hands doctrine out of there, and I put the maxim, he who comes into equity must be doing equity.
Okay, so then that would also be able to be construed as you have to come with clean hands because you're in equity.
Yeah. Now, if they want to construe it to be the other way, that's fine. But now I got it down on black and white. That's how I'm going to get into equity.
So that maxim would be one of the main ones that we would be using in our bills then, because that seems to cover a lot of ground. He who comes into equity must first do equity.
Yeah, in fact, that's the main one of equity. That's the first one they're talking about.
So now, what about a collateral estoppel through res judicata? Now, if one were to run what you would call it, I lost my train of thought just now, a notary presentment, and you actually have somebody in dishonor, you have your certificate of dishonor or your protest, and that creates an estoppel, like whoever's coming after you would be estopped from collecting, and by their own acts, that would make it through res judicata, like they're blocking themselves from collecting, from not doing a specific act that they were supposed to do to, I guess, justify foreclosing or collecting from you, correct?
Yeah. Mm-hmm. Did we lose him? I think we lost Marshall. Did we lose Marshall? Yeah, I believe we lost him. Floyd, you're up.
I remembered my question. When we do a trust, or I mean, when we're pulling our res out of general and putting it into special, we can write into our indenture that this only can be settled in equity, can't we?
Yeah, you could. Yeah.
Because we set the law of the trust.
Yeah, you could probably write it in there. Yeah.
Okay, that's basically what I wanted to find out. By the way, they received my delivery. It was delivered June 11th at 6:49 a.m. in Mission, Kansas.
We had it a day then. Huh?
Yeah, they got it yesterday.
Friday, yeah.
Yeah. Okay, so now we'll find out what's going on, and I'll call my Monday morning. I'll call my public notary and ask if she got hers sent out on the 8th or if it was the 7th. Because if they got it, because I sent mine out on the 8th and they got it on the 11th. So we'll see what happens. Well, anyway, that's what I wanted to find out, Christian. Thank you.
How many days did you give them?
Huh?
How many days did you give them from the time of receipt?
Well, on mine, I gave them 72 hours to answer me. And then on the one that she sent in, I gave them 10 days. So I'll find out whether they're going to honor the trust in my letter that I sent to them, my letter of dispute. I'll find out what they're going to do, because I asked them, what are you going to do about it? So we'll find out.
Okay, so your letter, you say you gave them 72 hours, but on the one the notary sent in, you gave them 10 days?
Yeah. Right. I gave them 10 days to pay the bill, but I gave them 72 hours to answer me as to whether or not they're going to pay the bill.
Oh, okay, I see.
Yeah.
So
is that
in writing?
Pardon?
In writing?
Yeah.
Is that from the time that they received service?
Yes.
Okay.
Right. Yep.
You received it on Friday, so that would be Monday, Tuesday, and Wednesday. So by Wednesday at 5 o'clock, you're supposed to have an answer.
Yes, right. So we'll see what happens by then.
Okay.
Okay. Very good.
Okay, in the corpus juris secundum, the first maxim in equity that they talk about is he who seeks equity must do equity, and that's under section 95. And it says that this is one of the oldest, best settled, and most familiar maxims in equity jurisprudence, has been considered the source of every doctrine and rule of equity jurisdiction. So it sounds like, they're making the doctrines out of the rules of equity jurisdiction, but this is the main one. This is the first one.
Okay, read that one again.
It's the he who seeks equity must do equity. And that's the oldest, best settled, most familiar maxims in equity jurisprudence, and considered to be the source of every doctrine and rule of equity jurisprudence.
Okay. Because this one says it's the same one, but they state it differently. It says equity regards as done that which ought to be done.
Okay, that's another one.
Oh, that's a different one?
That's a different one.
Oh, okay. Okay, read yours again so to see if I can pick it up in here.
He who seeks equity must do equity.
Okay, let me see here. Oh, yeah, one who seeks equity must do equity. Right.
That's the primary, the first one.
And my list, it's 1, 2, 3, 4. It's the fifth one down. So I don't know why it would be different, but anyway.
Alphabetized or something, or what?
Well, I don't know. It just says the maxims of equity evolved in Latin and eventually translated into English as the principles applied by equity. Among the traditional maxims are, and then it just lists these 20. And so, however they come out, that doesn't say.
Yeah, well, that one's you're required to do equity before having equity do for you.
Yeah. Well, I can understand that. But I think what we could do is any equity maxim that we want to use that's particular to our situation, we can just put it in.
Yeah, you can. Yeah, right.
And I think we should start using these maxims. I mean, they're there.
You're absolutely right. That's our equity. We're setting the jurisdiction. We're going to have to be using equity. Forget about the statutes and codes.
Yeah, exactly. And as long as this cuts through everything and sees the remedy, that's what we're looking for. So, anyway, are you still there?
Yep, still here.
Oh, okay, because I didn't hear anything. I even shut my air conditioner off so I could hear you. If you go, or whatever. Put your hand over your mouth or whatever. And by the way, I enjoyed your joke, even if nobody else did.
Okay. Well, I won't tell any more jokes anymore.
Oh no! I think levity is great. Anyway.
Yeah. How do you feel? Well, I don't feel up and down really, or in or out. I feel with my hands. Isn't that how?
Well, that's kind of what I would have said. I said, well, I feel with my fingers. Well, what's new?
That's how I feel.
Okay. Well, I think Chris enjoyed that one. He didn't expect it out of you.
I better follow suit here. So.
Yeah, right. You threw him a drop ball. What can I tell you? Oh well. So anyway, that was my that's what I wanted to find out, because I think that'll make our creations a whole lot easier if we just bring them right into equity right away.
Yeah, just come in with the right for the enforcement on the right, or the duty. Which is
right, exactly. And then we'll use the right maxim to put it around their neck and just yank them right in.
And what Chris was working on, come in with the Attorney General thing and put it directly into, say, the federal jurisdiction there on with the judge, that he's acting as the DIB hearing to do the public witness. Something that's already been done really privately. So. Yeah. Well, whoever you're going to approach for your DIB hearing, that's what you would tailor it to anyway, right? Yeah, we would do a show cause hearing with that judge to review it and then rubber stamp it, and that's it. Yeah. Right. Okay. Well, I think as time goes on here and when we start doing this, we'll get a little bit more educated, and we get some experience behind us, then we won't have any problems with wondering, any more about whether or not we're concerned about jurisdiction or not, because we'll know that we're in our jurisdiction. Right. And we'll know how to stay in our jurisdiction. Yeah, that's the thing. We're allowing them to jurisdiction without us knowing it. Yes. And it doesn't matter. It doesn't matter if you're in maritime, or if you're in statutes and codes, or if you're in state, county, international. It's all public. That's all public anyway. Yeah, especially if you're using negotiable debt instruments, credit. That's all public instruments. Yeah. If it's negotiable, it's all public. If it's non-negotiable, it's special. It's under trust, and it's non-negotiable. Private. Yep. And if we keep it that simple, we should be able to handle it. Yes, coming from a trust position, yes, because that'll give you the authority to claim that. Right. That'll give you standing to do the equity. Exactly. And then if they want to trespass, your privacy, then at that point, then you can clobber them with whatever after you get them in the. They breach the trust. Yeah, get them into trust. They breach the trust by doing that. If they trespass on they breach the trust. Yep, that's right. They're the ones that are commingling. Yeah, and then breach of trust. Well, that demands jail time too, by the way. So. In mens rea, willfulness, yeah. So anyway, I think we got the big club now. All we have to know is how to wield it. We've always been the 900-pound gorilla. We just never knew it. That's right. Yep. Well, we just didn't know. We always look at ourselves as little guys, So. So now we finally come of age. Age of majority. Yep. Age of majority. Right. Okay, Christian. Well, that's my update for the night. So we'll see what happens next week. Okay. Okay. Thanks, Floyd. Good night. Chris, you're unmuted.
Hi, Christian. It's Chris again.
Yeah.
I want to pick up, and I'm going to go back in the calls to Jacob. Marshall, with what he said about Trust Judica, I did just a search on that, and this is what it says. Term for a matter already judged and may refer to two things in both civil law and common law legal system, a case in which there has been a final judgment and is no longer subject to appeal. In the terms is also used to refer to a legal doctrine meant to the bar or preclude continued litigation of such cases between the same parties, which is different between the two legal systems. In the latter usage, the term is synonymous with preclusion. Now, the part that I was trying to bring forth before Jacob came on the line was how can we take a maritime lien, which is a private document on the private side of the maritime law, of which we have put on a UCC, and add that to our arsenal in our UCC trust res of when we use the trust papers to close and merge the titles for a settlement, and how could that benefit the overall amount of money or assets to be returned back to the settlor and or the beneficiaries. And with his usage of Trust Judica, it led me to collateral estoppel, of which he was speaking about too, which is part of what we're talking about with mandate injunctions, which ties directly right with that. And it led me back to what Jacob was talking about in regards to the unlimited jurisdiction under easements and surveys and trust as being part of the elements of how we set up a trust or an indenture in order to create or strike the parameters or the boundaries of that trust. So that was kind of like what I was thinking. The main core part is being able to bring in the maritime liens under public into the private within our UCC 1s and UCC 3s as we're merging the titles as part of the instruments of, you don't like to use value, but the instruments that will be part of the elements that has to be dispersed. Would that actually benefit us as a settler or the beneficiary to the assets that are being generated in the disbursement process, or would that be just another thing separate from the amount of money of the judgment of the maritime lien?
Yeah, so here we are generating a lien that's really a negotiable debt instrument and mounting up more debt again. So we actually ones created that, but there's a way to capture it, which is like, just like you said, withdraw it from that public realm that you created it from, and then put it into trust. And now you've taken it out of that realm.
So how would you do that? Would you make would you do like a UCC 1 as claiming it as a trust res, and doing a UCC 3 to bring it out of the public into the private, therefore it becomes a private document? Is that how we do it? Withdraw it out of the general?
Withdraw it from the general and redeposit it in trust as special.
Okay, and then that would be assigned in the merging of the titles when we come down the pike of presenting all documents, or I should say all trust res, that needs to be considered by the trustee that has the duties and obligations to execute the merging of the titles and the disbursement of assets to be given back onto the settlor and the beneficiary. Therefore, that would actually supersede everything with that included to that amount of money, right? Or that amount of assets?
Yeah, so when you pull it out of general, it no longer has a value. It's just a res. So once you put it in trust, it's...
Yeah, but is there a point of where it actually adds into becoming... When you do the disbursement, doesn't that actually add on to what is being generated back out of the liquidation of the debt and the asset side of the merging of the titles, and what is generated from that is a disbursement. Doesn't that increase the disbursement?
Yeah, I would think so. If they're going to cross it back over again, then you have to reconvert it back. And they could be the vehicle that could be used to convert it back over.
Yeah, because it's actually a judgment against them.
Yeah, I know, but that's why I'm trying to tell everybody, you know, I forget about these maritime liens and things. Stop creating debt on the public side because you're contributing to the problem. Don't use negotiable debt instruments. We could just take the debt title or the offer for creating funds and use that as the debt title to merge it as an asset title and then do the same thing. But now we're not the instruments that created the debt. We're extinguishing the debt. But first, the other way, we created the debt, and then we are extinguishing the debt. So we're back to, there's no progress there.
So in other words, that basically would be a wasted time and investment of funds to go ahead and assign a maritime lien to bring it out of the public into the private as part of your trust res when you merge the titles. Is that what you're saying?
I would think that we should take the maritime liens that we have created or the negotiable debt instruments that we have created, and we should start gathering them up and putting them into trust and getting rid of them, extinguishing them, because we created those messes and we got to get rid of them.
Okay. Now, going back to what Jacob was saying before he lost communications, he was talking about the abandonment, and it struck a chord with me that if there was this language used in papers where to offset the activities of the trustee once they've gotten a promissory note and a deed of trust or a mortgage, depending on what part of the country you're in, if they were to go against the will or they did not inform or ask for consent for the securitization and any of the activities, wouldn't you consider that the term abandonment of trusteeship?
All right, go over that again now.
Say, for instance, there was a trust relationship of where the grantor entrusted the trustee to handle in a meaningful way that it was beneficiary to the intent of the grantor. Therefore, once they've got these instruments, they prostituted them, put them on the open market without giving notification to the grantor that there was dividends being divided up among the thieves and that there was no announcement or dividends given back onto the trustee from his signature. Would you not define that as being an abandonment of the trustee of the trust?
All right, so if I was grantor and I gave a trustee some kind of funds and I didn't go back and have anything to do with it yet as grantor, then yeah, I would have abandoned it. But the only reason why I've abandoned it because I've been tricked into, they've formed this trust, tricked me into forming this trust, and I had no idea it was a trust. So if I didn't have any idea, naturally I abandoned it. I didn't know it was a trust. There's where the abandonment comes in.
Well, what I was trying to draw in a conclusion was not so much that's a nice idea that you brought up, but the trustee has duties and obligations to a trust of which they failed to do so because they immediately predetermined that they were going to abandon the wishes and desires and the intent of the grantor by taking the instruments, prostituting them, put them on the open market, collecting the dividends in their own profit margins without giving any compensation or consideration back onto the grantor. Therefore, that was abandonment of the duties and obligations of the trustee.
Yeah, but how he got away with that was because the grantor slept, because he didn't know it was a trust.
Yeah, but what the papers were doing, the reason why I wanted to bring it up is because the abandonment of trusteeship and the duties and obligations of the trustee, that they did not question or have any kind of indenture or any kind of documentation from the grantor of what the wishes and intent of the grantor. Therefore, they abandoned any respect or relationship respect or duties or obligations to the grantor, therefore they abandon the trusteeship in relations to the grantor, therefore they're in breach of trust.
Okay, yeah, but then if there would have to be somebody in the trust that would have to know that it was a trust. It would have to be the beneficiary or the settler.
Yeah.
That they could enforce the duty for the trustee to do what he was supposed to do. But if none of the parties knew that was a trust, then, yeah, they abandoned the whole trust. And that's basically what we've all done, because we've all formed all these trusts and we didn't know they were trusts, so we abandoned them. But now if we know they're trusts, I don't see how we could abandon them. In fact, we're going to go in there and we're going to enforce them. So it's, abandonment would be only if you didn't know, and now it's, say, everybody should start waking up and start knowing that all these things we're doing. We're putting general deposits in and abandoning them because they're really trusts. We're not giving any indenture instructions to these trustees, so they're sitting there, securitizing them and do whatever they want, holding them in trust for us, and they're using the funds, holding them, taking care of them, really.
Well, I guess the finger pointing that I'm trying to come to a conclusion for everybody's just acknowledgement here is under Gilbert and under CJS and the assorted other Bibles that we've got that we use under trust law, the trustee has X amount of duties and obligations. It is to follow the instructions of the grantor / settlor, which could also be the beneficiary, blah, blah, blah. But the thing is, trustee is to execute the wishes and desires and the intent of grantor, of which premeditatively, they had absolutely a trespass, a criminal trespass, by abandoning any wishes that would have been honest and upfront of what the wishes and the intent of the grantor. Therefore, they departed from that right off the bat. Therefore, that becomes a criminal trespass and a breach of trusteeship to a trust, with or without the person's knowledge that that's exactly what happened. Yeah. In other words, if I went out and shot somebody tonight, and I had been stalking them for 6 months, and then finally I got them to where they were at a certain location, and I shot and killed them, well, that's premeditated. Well, the way the industry is set up right now is based off the same principle. They have no intent to honor or respect the signer of that document. They have prostituted, they have denied you complete understanding of what it is that you're involved with their activities. Therefore, they have abandoned the true sense of what an honorable, respectable, within the realms of what trustee has been named in all of our Bibles on trust law.
Yeah, well, where's the indenture at? Where's the will of the grantor at?
Well, that's what I'm saying is that I think that this is just another area that we're going to have to really, when we get ready to put our packages together, I think the indenture is one of the things that's coming up on my list to put my attention on.
Yeah, that grantor would have to express a trust and give some kind of instructions, and then when he didn't do the instructions, then definitely would be a breach.
Yeah. But going back to the easement and the survey that was touched upon with what Jacob has done this last week, I do believe that a trust does include relationship negotiations or diplomatic treaties with others. So therefore, some of that language with surveying and easements seems to have part of an indenture in itself, don't you think?
It can, yeah.
Yeah, because that's what I'm looking at right now. But I think the main thing is that I want to know what I can do right now, to harness, to actually, without commingling, utilize the maritime liens that are on UCCs against these debtors and how that can be utilized and used as a trust res, or as Marshall was saying.
Really, with trust, we don't really need any liens. We can just extinguish the debt that they're hitting with us. I mean, under the debtor-creditor thing, we create a counter debt, which we're going to use as a set-off against it, and use that as a bargaining chip. So,
okay.
But I don't think everybody realizes what they're doing is they're double debting now. They're creating more debt on top of that, which is compounding the problem.
Well, I understand what you're saying, and I'm still trying to wrap my mind around that. I mean, I haven't came to a full conclusion of my own that I can just exclusively work under, trust or equity. I'm actually still toiling, or at least still entertaining the idea that the debtor-creditor side is kind of my sandbox where I can play and really become really strong. And like I said before, trust and equity becomes my safety net. And I still entertain the idea of going after these guys to either prosecute, put them in prison, and or collect a phenomenal amount of money in their terms as debtor-creditor, and be able to play,
debtor-creditor route.
Yeah, to be able to play both sides and become a master, because, I mean, you got to look at commerce is not going to go bye-bye. It's just impossible for that to go bye-bye. So therefore,
it's going to go bye-bye. Yes, it is. It's going to be eliminated.
Well, all right. I won't argue that point. But anyway, I think that's it for me. I was intrigued about the Section 95. Can you post that out for us under CJS?
Yeah, if I could get it copied, I might be able to.
Isn't that the section you had, he who seeks equity must do equity?
Yeah, that was under the maxim section, yeah.
That gave the definition of all that language?
Yes, uh-huh.
Yeah, that'd be great to have that, because a lot of us don't have the CJS. So. Anyway, that's it for me for right now. I'll let somebody else come in.
Yeah. Oh, I think it needs to be brought out more about this debtor-creditor realm. I don't think people really understand that creating more bonds, creating more promissory notes and things is actually compounding the problem. You're doing a negotiable debt instrument. You're making it a negotiable instrument, and then we're going to think that is paying a debt with the debtor, and it's not. It's just compounding it.
Did you give it any thought about what I told you last week about there's only 3 true creditors that came out of the Security Exchange Commission Act of 1934 that named the IMF, the U.S. Treasury, and the person that's signing the documents as the only true creditor parties that exist, that all other are debt collectors?
Yeah, and out of those 3, the only one who's really the sole source is us. Yeah.
And can't we use that as true creditors to offset anybody that's coming at us? And, I mean, I understand what the Form 101 in the UPU is talking about by having a brand new, fresh account that's been bonded. Therefore, we can start anew, at least with that, and have access to a credit card and cash. And we can go back and clean up all these other messes at some future date when we have some funds in our pocket. How did you feel about that? I mean, being a true creditor and being able to have access to an account like that.
Yeah, if true creditor means that the source is really on the private side, then I'll agree that really a creditor is really the grantor. And I'll agree with that. But if we're talking secured party creditor doing commerce, no, I don't think. I think we want to disconnect totally from doing commerce. Can't do commerce anymore because you're making the debt mount up doing commerce. Now, there is a way to get what you need through commerce by not doing commerce because you're just a consumer.
Yeah, but that's what I'm trying to point my finger at. You're right on the money with saying that. It's my belief that if you exempt yourself from the circus that the United States government and their commercial enterprise of debtor-creditor, you exempt yourself out of that. You get into a brand new, completely neutral postal zone of where there is a brand new issue of bonds of which you exclusively, as grantor, can go, or co-trustee.
Well, there's where the first mistake comes in, the bond. What's the bond from?
Well, apparently it's posted internationally, so it's going to be above, but I guess the U.S. Treasury has a hand in it.
Bond is a negotiable debt instrument again, and there we are mounting up debt.
Well, you've heard of e-credits, haven't you? That's pre-currency value. You've heard about e-credits, haven't you?
I believe I have, yeah.
Okay, e-credits is not currency. It's value like trust res that has no denomination in any kind of currency until you bring it into the public.
Okay.
And that is what I'm talking about. If you were to have a bond placed on your UPU registration number, therefore you set up a legacy account that's bringing down true credit, that's not debt. That's not any denomination in currency until you actually activate it.
A bond is a promise. You're going to promise to pay. You're going to promise to come up with something. That's a debt.
Well, so what you're saying is that the generation of interest on true credit is lessened and put into the filth and the criminal activity of the debtor-creditor currency. Is that what you're saying here?
Yeah, because if you give me a bill for any harm that I've caused you, I will extinguish it with an equitable asset on the private side. I'm not going to a bond and put it into that realm. No, you give me a bill from that realm, and I will take care of it.
But if you're dealing with pure credit that stands completely on the private, separate from currency, which is public, therefore you execute everything in the private with your e-credits, and everything's being taken care of on the private, would you have other considerations about that? I mean, as an activity that you can participate with?
Well, what am I putting up as the promise to pay them?
Well, I would say that based off of the understanding that you are a true creditor.
Don't I give them something?
Yeah, you'd be given e-credits. E-credits would be non-denominational as far as it goes for currency. Or it could be.
How do I get these e-credits to give them?
Well, this is what I'm talking about. Is with my understanding, Christian, and with my background with so many different groups, is that there is a system which is on the private, just like I said with maritime law. There's a private system of securities that are true credit that are exempt from currency. Therefore, it's your own discretion of how you go ahead and utilize or bring it down into gold, silver, or currency of any nation.
Okay, now as soon as I convert it into a currency of any nation, there I'm back in the debtor realm again.
Well, what about gold or silver? Because it's convertible right into gold or silver.
All right, now that may be different there because we're not using gold and silver as money.
Yeah, that's what I'm saying, is that the ability of e-credit stands separate. It stands as the ultimate gem of any consideration of credit, and it's pure. And if you're given an allotment, or say 30 million credits, 30 billion credits, whatever, these are units that can be converted in any denomination anywhere in the world, and they're honored, and they're not currency.
The pivotal point is when you use the word credit, because that could be construed either private or public.
Well, I think that unit is better, but I mean, words are going to fail the concept here. I mean, at some point, everybody's going to have to recognize that there is an underlying private side to and far beyond the words that we've been using, which is debtor, creditor, currency, gold and silver, and all this other stuff. When you're issued units, let's just use units. These units are good privately and publicly with your discretion of how you'd like to use them. Therefore, that is like a pure trust res to me.
Yeah, well, as long as we stay away from public credit, public Federal Reserve notes, any fiat currency in the public, anything that the public has generated, that's what we got to stay away from.
Yeah, and I understand that, but I wanted to bring it up because I know that nobody's heard e-credits before, and they have not heard international units as being the real substance behind the scene. And I've heard a lot of stuff from people that work at the U.S. Treasury that I personally know that they say that stuff does exist, and it is before currency. Therefore, anytime you're issued pure credit, those units can be utilized anywhere in the world because it's recognized by every government, UPU, and everybody else that it's not a debt instrument, it's pure credit. It's completely different. It has pure value for any form of usage that you choose to use it for.
Why not go to the post office and just buy money orders? Because that's from the original post office that's still backed by gold and silver.
If that's what you want to use your e-credits for, yeah, I would say that you're right. I would prefer just going ahead and just buying junk coin and get it over with because that's your best value this day for any future exchange with common people. If the system they've got going on right now collapses, is that junk coin, you know, those dimes, nickels, and the dimes, quarters, half dollars, and silver dollars, that junk coin at cost, which is about $14 an ounce right now, will be worth a whole lot more to buy a piece of bread than a piece of paper or an e-credit. So investment I do is going to be either in gold or silver. Or seeds, organic seeds. How about that? Non-altered seeds.
Cigarettes, vodka, you know, any kind of stuff for trading.
Exactly. But anyway, that was what I wanted to talk about, is how to convert maritime liens into the private. Since they're a private document to start with, it should be easy, and use that as a trust res as part of your leveraging. So
well, I would stay pure trust. I would stay away personally from all negotiable debt instruments.
Because you know you're probably right about the maritime liens. If you're going to function on the debtor creditor side and play both sides of the podium, is you might as well just keep that in the public and treat that as a completely separate issue. That brings up exactly what I was trying to present to you as a question earlier. Is just that I'm at this dilemma of where I need to play both sides. I can't just completely step away from the debtor creditor because I know too much. I can win. And I can win on its own terms, and I can continue the private side with the trust and the equity. I mean, I can play both sides and be a master.
Yeah, well, you know, a child is weaned off the bottle until finally he can really, you know, chuck down meat.
Yeah, or vegetarian or whatever.
Yeah, so it's a, you know, there's a time you go through where you're going to go through a transition period that I can get off of this.
Yeah, and you know that may be just what I need.
I never thought I could do it with Windows, and I would have to keep a dual system. You know, I haven't touched Windows. All I do is Linux.
Yeah.
I don't need it. Finally got off of it.
You know, for me, Christian, you know how long I've been in this stuff. It's 11 years solid. You know pretty much who I am and what I've been doing. When I start getting confirmation with all the documents and stuff that I've been cranking, you know, out of this camp on trust and equity, when I start getting confirmation and successes, I'll be a true believer. But I can't let go of that last branch thinking I'm going to fall to the jungle basin without any confirmations. I can't do it. I mean, that's just who I am. I have to have total, absolute control, because if I don't, I'm no longer the grantor. I'm subject to the trustee, whatever whim wants to beat, punish me, and take everything away I've got. So I have to be absolutely, at this point, in absolute control. That means until I am actually a true believer with wins and percentages, not just wins, but percentages, I probably won't let go of the debtor creditor just because I need to confirm. I need it, in order for me to move forward. And I will give up the debtor creditor stuff, provided that, what we've been working on actually does do what it's supposed to do.
Well, time will tell, and we'll have to wind the machinery and pre-program it to work the other way. And
I'm game for it. You know how long I've been in this stuff for 11 years. I'm willing to grab the horns of that bull and bring it to its knees. And I've got the power. I know who I am. I will bring that bull to its knees, but I have to know for sure. And I'm not quite there yet. I will get there soon. I didn't come on board until January, and here it is June. It's 6 months. And I'm pretty sure that we're on course. Everything we've been doing, it's just like it instills me, it inspires me with what we're doing. I have inspired so many people here in California that everybody's like a hair trigger waiting for the next, success here. But being a private attorney general, being in the stats, I don't know. I don't know. I had to have verification, and I can't wait.
Well, there's a time for planting and a time for harvest.
I think our harvest time is coming up. Oh, by the way, did you have any considerations of the paperwork for the notice of fault and the default paperwork? Did you want me to start that up and get that running, or what?
Yeah, because I don't know if anybody else is working on it.
And because that's coming down the pike. 14 days is a very short period of time not to have something. So I'll work on that. I've got a couple more cases to work on between now and Monday, and then get them done. I'll start working on those notice of faults.
Okay.
Anyway, I'll let you get back to the Q&A. There's probably other people wanting to talk to you. Thanks for everything.
Okay, Chris, thanks. Seven 773, you're unmuted.
Christian?
Yeah.
How are you? This is Mike in Chicago.
All right, good.
We're here in Chicago. We got a small group, and we are working on details of the paperwork. We would like to send to, let's say, credit card, bank, company. Right. And we were thinking in the lines of when we're gonna send back to the bank merge document with our notices of claim of title and withdrawal of general deposit, UCC 1 and UCC 3 plus counties. My thinking is that if this is rather a question, do you think that at the same time I'm returning back, depositing the special deposit, should I have prepared already UCC 3 and county for such special deposit? Because I'm thinking that chronologically I should not have notice filed before I really deposited this deposit. Do you follow me?
Those are just notices referring back to a past date. And really, when was it that you actually signed the credit card application?
So this is the second set of UCC and county.
Yeah, all we're doing is correcting something that's already been happened, in the past. So it's already taken place.
Okay, so it's not like we're depositing this; we're rather re-expressing it.
Yeah, because it actually happened in the past, and we're just correcting the records and giving notice now.
Yeah. Okay. Okay. Yeah, we're working on little details, in preparing documents. So these things are coming up. One of the other things was, do you think if in this withdrawal UCC3 we should incorporate the word withdrawal in the notice itself, or transfer is good enough?
In the notice?
Yeah.
In the notice, you might want to put withdrawal.
Okay. All right. Okay. That's good. Another thing is, let's say we're working on a credit card, okay? So let's say I send back to the credit card company my notices, merge document, and the order of terminating the trust. From the practical point of view, do you think do you agree with that if we order statement of the accounting and all the proceeds to return to us, the bank won't be that eager to really extinguish the debt, because they easier accept the fact to extinguish the debt than returning all the proceeds? Do you know what I'm going to? Just to not request to return the proceeds or itemized statement back to me just to extinguish the debt. And that would eventually solve the problem of the debt itself. It's not like picking up further fight, You know what I mean?
Can you come at that from a different direction?
Yeah, I was listening to Marshall Wednesdays. Actually, I made a transcript of it, so for me to really understand this. And in his situation, he was talking about foreclosure, and he was ordering to terminate the trust. In the document he would send, he would order to terminate the trust and ask for itemized statement of all the proceeds which were generated out of his signature. Okay, and if I would send this order to for them to send me itemized statement of all the proceeds, they most likely won't do it. Will you agree with me? But if I order just extinguish the debt, there's a better chance they will.
Well, each scenario could be different. They may on one bank and they might not on another bank.
Yeah, but my question is, do you think from practical point of view it would be more acceptable for them? Because otherwise, if I ask for extinguishment of debt, right, they might do it, But if I ask them for all the proceeds returned to me, I mean, that's really hard for them. They would know it's a breach of trust automatically, because they probably won't do it.
Well,
you know what I mean?
They're going to have to know, in fact, they probably do know, that they're going to be in breach of trust, and they're going to be enforced on the trust. So you kind of got them between a rock and a hard spot. It's sure if they did it, it'd be a whole lot less problems. But if they didn't, you're going to have them anyway.
Yeah.
They're going to be forced to do the extinguishment of the debt, whether they like it or not.
Right. But for someone who has like multiple credit cards, and immediate remedy would be just to get rid of the debt, Like I have many cards, okay, but I'm current on all of them, okay? I'll be very happy just not to have my payments sent every month, you know what I mean? And if they look at what I send them, right, it will be more acceptable for them just to extinguish the debt hoping that problem will go away, than just extinguish the debt and then send all the itemized, itemized statement of the proceeds they generated. You know what I mean?
I mean, give you the proceeds back.
Say again, please.
You mean give you the proceeds back that you paid your payment?
Right. I mean, it's easier for them to extinguish the debt and hoping that the problem will go away than just extinguish the debt and send all the proceeds.
I know they might not like to do that, but the trouble is every dollar that I gave them, they made $10 more on it. I mean, my general deposit, when I gave it to them, whatever the value was, actually created 10 times more.
Don't get me wrong. I would like them to send me those proceeds back, but
Just give me the dollar that I sent you that you made $10 on. Give me the $1 back that I gave.
I would like to see them sending me this money, or whatever it is, currency.
They had the use of 9/10 of it. Give me the 1/10 back that you kept all 10/10 of it, plus the $1 that I gave you.
Okay, I got you. That's a good solution. I mean, still keep some, but send me back, right? A little bit of it, like I want $1. That's what you're saying.
Yeah, there's any way combinations you can work this. You could.
Right. Okay. I understand. All right. Another thing is that I have lots of driving time, and when you're having your calls at night, it's too late for me because I'm waking early. And I've noticed on your ForShared account, you don't have like a May downloads. Is it possible to receive them?
Not at this point, no. I'm holding them back until I get the website up. So.
Okay, I understand. Okay, all right. I don't have more questions right now. Thanks.
Okay. Appreciate it.
Okay, thank you.
Nobody else, thank you? Okay, it's 12:11. Might be a good place to call it a night. So I think that's what we'll do. So I thank you all for joining me this day. Here it is, Sunday now. So I'll see you all on Monday, and we'll start again. So